Good morning, everybody. Happy Friday. Welcome to the Courtroom Files Live. Good morning to everybody in the chat. Carissa, congratulations on becoming a channel member. Great to have you here. There's a whole lot of landlord-tenant going on so far this morning, and it's one of our least favorite places to go. So let's start with Judge Glazer in Miami-Dade and see what's up there today.
Probable cause for the charges. I understand it's from July of 2023.
When was it reported, Your Honor?
I was just looking at that now. The police case number says, it's weird,
I think
It
March,
says
if Your Honor looks at
March.
it says on March 23rd, 2025, they responded to the address.
The police case number is a 25 case number. Okay. I'll set a bond. Count one will be $1,500. Count two is $1,000. Is that okay?
Yes, Your Honor. And then to be clear, so there's no issue with corrections. There's no hold, no nothing. He can post the bond and get out, correct?
Directions, did you mark the jail card no hold?
Yes, Your Honor.
Mr. Berkeley, that's fine. There's no hold. He can post his bond. If there's any issues, we're here in the afternoon. Come back and see us. Okay.
Okay.
Thank you, sir. You have a good attorney. Listen to what he tells you and make sure to keep all future court dates. Stay away from the victim. If she calls you, do not answer. Call your lawyer. Okay.
Thank you,
Thank
Your
you.
Honor. Thank
Thank
Have
you,
a nice
Judge.
day.
Thank you.
I read the stay order, right? Yeah. Okay. I didn't mark it. Usually I write it and read it and that's it. I know it. I signed it. Okay. Next we have any added terms for corrections. We have on page 1, Erica Pena.
Your Honor, she refused court. We need to reset her for the PM.
Let me
Your Honor, please
review.
And corrections, can you tell me about the fugitive warrant?
It's from Broward, no bond. Did you hear me?
Yes, thank you so much.
Okay.
Corrections, you said she refused.
Yes.
We'll waive her presence.
Okay, appoint the public defender's office. Waive her presence, setting a bond. Count one is $2,000. Count two will be $500. Appointing public defender's office, waiving her presence. There's probable cause for counts 1 and 2. Next, we have Jeffrey Williams. Page 7. Good morning, Mr. Will. Is that Mr. Williams or is he refusing?
Mr. William?
That they told me to call that one next for corrections. I don't know if it's right. Page 7.
Page 7.
No, Your Honor, Charles Williams is, he's page
I had 17 as somebody.
page 13. Charles Williams, page 13.
The gentleman beside you.
Then I'm gonna do the chill.
This
Well, this is the one that was next.
Oh, so we're doing
Okay.
out of facility now then.
I don't know. I'm calling the ones that the clerk and my bailiff handed me, so
You
no
didn't agree on
worries.
an order and before we
You see, I'm just gonna go with the flow. Who's the next one?
This is Charles Williams. He's on page 13, number 39 on the calendar.
Thank you. Good morning, Mr. Williams. Sir, you were arrested for using a computer to solicit or lure a child to engage in sexual conduct, 2 counts, and 1 count of sexual possession of pornography. I will appoint the public defender's office for you. So it's an added charge. It's from June 28th. Let me review for probable cause. All right, so
Judge, I have some probable cause argument.
go ahead.
So with regard to the first charge, it should only be one count. And on the second charge, should be no probable cause, as it needs to be sexual conduct. And there's no sexual conduct.
State. Doesn't it per se if the fact it's a child and he's taking a photo and saving it in his phone to view the photograph?
Let me look at the statute because it's definitely lewd in nature.
Anyway, sir, while this case is pending, no contact with the alleged victim whose initials are WR, no contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victim, his home, and school at all times. So
So
Say-
definitely,
It has to, sexual performance is performance or part thereof, which includes sexual conduct.
but it would be possession of child pornography.
okay. Count one, there's probable cause for the charge of improper use of a computer to solicit a child. That's a second degree, I'm sorry, it's a second degree
think there's
felony or
one-
third?
Third,
The third degree felony, it's a $2,500 bond. I don't know if you want count two, if you want $1, I don't see probable cause for count two.
Is it just
$1
one
is fine.
picture?
He sent what, more than one picture?
Let me look. It looks like there's two kids, right? Because it said the 13-year-old said he
There's
was
another,
FaceTime call with the defendant and a 10-year-old.
it looks
And
like the 13-year-old took a
took the
picture
picture.
of the FaceTime call that accidentally captured the other one's part and sent it.
So no, keep on reading. And then he heard grandma coming, so he hit his phone in his pelvis area, exposing his private parts to the camera while on the FaceTime call.
It says on 2 occasions, this is
There's
why
probable cause for
on
count
2
two.
occasions, he asked him to send pictures of his private area.
It's $2,500 count two.
What does it say, 2 occasions?
So if the paragraph starting on Wednesday, August 13th, in the middle, it says on 2 occasions, the defendant asked him to send pictures. So there's
Okay,
2
gotcha.
solicitations.
Count two is $2,500. Count three, it's possession of, I believe child pornography. That's going to be a $2,500 bond.
Corrections, he's being held no bond on other cases, is that correct?
Correct.
He has other cases. He was the basketball coach. Good day, sir. Next, we have George Ronquillo on page 8.
Judge, I'm gonna need a new microphone here. If IT can get me a new microphone, this button is not working well at all.
Okay,
This is you're number 17?
Mr. Ronquillo, sir, good morning. You were
Judge, this
arrested.
is Mr. Simon.
I guess it's not Mr. Ronquillo.
No, number 17 should be before Mr. Ronquillo.
You know what? Monday morning, I'm getting here at like early. It's 8 o'clock, and I'm gonna make the calendar because I can't do this anymore.
This is Frederick
that was
Simon,
me.
Miss Corey.
Wasn't me.
Yes, you're Mr.
It's not
Simon.
you. It was you?
It was me.
Everybody is having too much cafe con leche in the morning.
Or maybe not enough.
Not enough. It's okay. He's worried. His doggy's getting neutered today. Right?
Yeah.
Oh, he's upset. What kind of doggy is it?
Haven't
Havanese. Oh, poor little guy. Okay, we have Frederick Simon. Good morning. Sir, you were arrested for fleeing and eluding a police officer, resisting an officer without violence. I will appoint the public defender's office for you. You're out on probation, felony probation, for 3 cases for F23-3976, F20-4261B, and F24-11370. So there's a hold for you to see your judge on Monday. And I need
Yeah,
a mo-
he's also on probation on F20-4261B.
Thank you.
Total of 4 cases.
So that's 4. All right, so hold for the division judge. I need a review for probable cause. So it looks like it should be fleeing and eluding at a high rate of speed, the second degree felony. All right, there's probable cause for count one and count two, $5,000, I'm sorry, 2,500 count one and $500 count two. Have a nice day.
Now we have Mr. Ronquillo.
Okay, thank you. Mr. George Ronquillo on page 8. Good morning, sir. You were arrested for battery on a law enforcement officer and resisting an officer with violence, criminal mischief, and I will appoint the public defender's office for you. So it looks like it's,
Start reading middle of page 4, paragraph, starting with immediately following the arrest.
so it's coming from a DUI check, a DUI stop. What, page 4?
Yep, paragraph starting with immediately following the arrest.
So it kicked Trooper Hernandez in the face while resisting, I guess, going back into the vehicle. There's probable cause for the charges except count 2. I didn't see a value for the damage to the rear, that window he kicked.
Yeah, count 3.
Guess he's having a bad day and he refused, so you get an automatic 1-year driver's license suspension. Count 1, battery on a law enforcement officer is $5,000. Count 2, resisting an officer with violence is $2,500, and count 3, criminal mischief is $150. Good luck to you, sir. Next we have is, I hope it's the next one, page 8, Diaz Hernandez. All right.
Corrections, Diaz Hernandez doesn't have any holds, does he?
No, he has a misdemeanor, no valid driver's license, and he's going to jail arraignment next.
Okay.
He prefers Spanish, please.
Morning, sir. You were arrested for attempted fraudulent use of personal identification. I will appoint the public defender's office for you.
So he's got a
Sí, buenos,
fake social
buenos días,
security
señor.
card.
One moment.
Sí, ¿fue usted arrestado, señor, por uso o por por intento de uso de una identificación personal? Le voy a asignar un abogado de oficio.
It's a fake social security card and permanent resident card that he said he uses for work.
Sí, tiene una tarjeta de seguro social y una tarjeta de residencia permanente que dice que utiliza para trabajar.
No
there's
criminal history that I'm aware of, and I think he's been here since 22 in the United
Dice
States.
que no estaba al tanto y ha estado aquí en los Estados Unidos desde el 2022.
All right. Pretrial services, alternate bond, $2,500. Have a nice day.
Servicios previo a juicio y una fianza alterna de $2,500. Que tenga usted buen día.
So good morning once again, everybody. Welcome to the Courtroom Files Live. Lots of kind words in the chat for me this morning, and that's very much appreciated. But as I've said before, this does not happen without all of you. So thanks to all of you for being here every day, choosing to spend your time with me. I know this sounds very much like an airline, but we realize here at Dan that you have many choices in where you can watch your YouTube. But it's true, and you pick this place, and that never goes unnoticed. So again, thank you very much. Let's continue to ride with Judge Glazer for a little bit. I'm still waiting for other courtrooms to come online, but we'll hang here for a little while.
De un delito a un oficial.
So
I will
he
appoint
got-
I will
Sorry.
appoint the public defender's office for you.
Le voy a asignar un abogado de oficio, señor.
So he got into a hit and run crash, and then he reported his car stolen and signed an affidavit to that effect.
Sí, él tuvo un accidente y reportó su vehículo robado después del hecho.
There's probable cause for the for the charges.
Y hay caso aprobable por estos cargos.
So count one, perjury in official proceedings is $2,500. Count two, false report of a crime is $500.
En la acusación número 1, perjurio de un proceso oficial, $2,500. Acusación número 2, reportar el falso reporte de crimen, es $500.
Corrections, did you say an immigration hold?
Yes, Your Honor.
Immigration hold, sir. Good day.
Además, tiene usted una orden de detención por parte de inmigración. Que tenga usted buen día.
It looks like he's from Nicaragua. All right, next we have
Ashley throwing down early today, 20 gift memberships. Thank you so much. I think there's even a name or two in there that I recognize, so that's very cool. But yeah, you guys are the best. This is the best community out there. We may not be the biggest, but as Michael pointed out the other day to me, we have like 100% interaction here. This is something that doesn't happen anyplace else. You guys spend time talking to each other. You discuss the cases. You discuss what's going on with each other. And it's just absolutely amazing. So thank you so much, Ashley, and thank you to all of you.
Causa probable de estos cargos, la fianza es $2,500. Que tenga buen día.
Would you consider any program? This is a scooter.
no. Fleeing a police officer, no.
Right, it also talks about a struggle, and he's got an open case.
So is that it for the attorneys for corrections, or any other private lawyers appear that need to be called? I'm happy to call them. Any victims, witnesses? Otherwise, we're going to start on page 1. Let's see, page 1, Letitia Ortiz. She's out on bond, hold for F-25 9690. Good morning, ma'am. Mr. Ortiz, you were arrested for unlawful possession of 5 or more identifications and petty theft to a dwelling or curtilage. And I will appoint the public defender's office for you. You're out on felony bond. There's a hold plea to see your judge on Monday. I just need a moment to review for probable cause. Is she, what, stealing mail?
Yes. They found her with 34 pieces of mail belonging to different people, including bank statements, credit card statements, and other personal identifying information.
There's probable cause for unlawful possession of 5 or more identifications and petty theft. Count 1 is $2,500 and count 2 will be $150. Have a nice day. Next is Sierra Jones, page 1.
Run it out.
Thank you. Erica Cruz. Oh, I don't need this one, Eric, if you want to dispose of that. Thank you. Good morning. So, ma'am, you were arrested for possession, I'm sorry, improper exhibition of a weapon on school property and aggravated assault with a firearm. So I will appoint the public defender's office for you. So this was yesterday at an elementary school. There's somebody here for you. Who are you, sir?
Hi.
What? Oh, the father, your child's father is present. Let me just review for probable cause. I guess you didn't have a good first day of school. Okay, I had a chance to review the arrest affidavit.
So Judge, for count one, it has to be exhibited. There's nothing indicating that a firearm was exhibited, Judge.
I don't think you can even ever possess it on school property. Oh, boy. Stay away from the alleged victim, Jennifer Escobar, no contact with her, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victim or home, school, and place of employment at all times. I'm sorry, you said for count two, it doesn't look like she exhibited the firearm. She just said to the lady, who I guess is walking too slow across the street with her autistic son, that she better move. She didn't say it
Correct,
that
Judge. She did
nicely.
not display or exhibit it in any way. The possessing or discharging weapons or firearms at a school-sponsored event or on school property indicates a person who exhibits a firearm. There's nothing indicating she exhibited it, Judge.
Trying to
Okay.
see what the charge is for possessing.
How do you know she didn't leave her purse in the car when she took her kid into school?
Well, the purse was in the bag, and
She's driving.
no, well, she told the victim, let's see, got out. Okay, defendant then stopped her vehicle, got out with the purse, stated to the victim, say one more word and I'm going to shoot you in the face.
Okay, but if she didn't show a gun when she said it, how does she know she had a gun? I think you have to show the gun in order for it to be an aggravated assault
But
with
I
a
think she
firearm.
brought the gun onto school property, is what I'm saying.
They're in the street.
No, it said, okay, well, it said the victim further stated defendant closed her bag, got in her vehicle, and went inside the school.
Uh-huh. A lot of ladies leave their purse in the car. I mean, it doesn't say here.
The defendant was detained and the purse was seized.
Well, if she didn't exhibit the weapon on the school, it would not be probable cause for that charge based
Let
on
me
what Ms.
see if
Corey's
there's a
telling.
separate charge for possessing. Here, so it's, let's see.
Count
It
two would be assault.
It would be 790.1152C1. I can put.
And I don't know, the aggravated battery looks like it was an accident.
No, I think that she said, well, let's see. She said, hurry the fuck up, and then the defendant's vehicle bumped her side of her person. So it doesn't look like it was an accident.
Doesn't look like it was intentional either, Judge.
Per the victim, defendant intentionally struck the victim against her will with a vehicle. Count three, there would be probable cause. Tell me about the count one.
Okay, so let's see, 7.
Or count, yeah, count one.
All right, let's look at the statute. It was.
Exhibits. So count 2A.
Okay.
It would be under 2A. So count one, there would be probable cause. Count two is a probable cause for assault. And count three, there's probable cause for the aggravated battery, although because she's victim says that, although I recognize it could have also been an accident.
I think in
She-
the context, it seems like it was on purpose.
Judge, it's not, just because the alleged victim says
You
it doesn't
know,
mean that that's an intent by Ms. Cruz.
all I can say is what a terrible way for your child to begin the first day of school with mom getting hauled off to jail. You know, you have to be an adult and set a good example and keep your, you need to relax. It's very upsetting. What do you want to say? Anything? Do you live with her?
I just stayed up with taking my son.
You were there?
Yeah, none of that.
Yeah, the father's here and he's saying none of that happened like that. Speak in the microphone. What's your name?
Tori Hobbs. I mean, it was just, she knew the officer that spoke Spanish, so she was older, so they went to talking in Spanish and he went with whatever she said because her purse was in the car. She never had a purse on because they was out taking pictures, so she had a phone in her hand. So that, she never put exhibited gun, shoulder gun. The lady, she never even hit the lady. She backed up the lady. She told the lady, you see me backing up, why would you try to come out? And the lady went to cussing out in Spanish. Then they stopped. The police came way afterwards. This was outside the school. It was never inside the school. And we dropped him off at the gate to the security. They walking, so we never made it inside school at all. He was across the street from the school, to be exact. None of that.
Yeah, there's always two sides of a story, and the truth is somewhere in between. Okay. You want pretrial? I'll give her pretrial.
Yes, please.
Pretrial services alternate bond, count one, possession of a weapon on school property. It could have also been in the school safety zone. I'm not sure, but that will be, I'll set that bond at $150.
Judge, it's an F3.
Okay, then I'm finding no probable cause. Release outright.
I'll bring the officer in for a PC hearing, Judge.
Call him right now.
Let me see.
I'm not gonna make her sit in jail another day because there's a little argument because of this incident. Call him right now, and I'll do it.
Let me see if I have contact information for the officer.
I want to know if he saw her walk into the school with her purse with a gun. Taking a short break while the state reaches out to the officer.
Judge, do you want to do Ward D real fast?
I'd be happy to, but I think Ms. Eth needs to be present.
Oh, yeah, you're right. I guess.
I also have other questions for the officer about the aggravated battery, so that would be nice if he comes in.
So I'm going to hang here for a minute because I'm curious to see if this officer shows up, and oh, I think this might be him. All right, hang tight. No, I guess that's not the officer. It's somebody in a hospital bed. Anyways, take this opportunity to remind you that as of yesterday, this show is now a podcast. The last few episodes are up. You can find it at Apple Podcasts, Spotify, iHeart, Audible, any place where you get your podcasts. You can find it. If you need a more audio and portable and downloadable version of this show, usually goes up a couple of hours after we are done with our live here. So be sure to check that out. If you do spot us over there and you get your podcasts on a place where you can leave a review, please do so. That will help it get found by others, and we'd appreciate that.
Who's the person for Ward D so I can get it next?
I gave the officer the information. Hopefully he'll log on soon.
Okay, have a seat, ma'am. We'll be with you in a moment. Have a seat, sir.
That's
Who's the person-
Jesse Ade, page 14.
Thank you. We'll do this case now. All right, Jesse Ade. Good morning, sir. You were arrested for 2 cases. It is possession of cocaine, trespass at a construction site, possession of drug paraphernalia, and resisting an officer without violence. That's from August 13th. And you have another case for 5 counts of failing to register as required by law. I will appoint the public defender's office for you. So he didn't report as required by law. All right, so on F25 17532, Ms. Corey, anything you want to say or no?
It'd be 4 counts, Judge. So if he didn't report within the 48 hours, that would have been the first month. And then until July 26th, because we haven't hit August 26th, that would be 3 more. So I'm okay with $1 for the last one.
Okay. So count 1 through 4 will be $2,500 each count. And count 5 will be $1. And then the other case, I have to review.
On the other case, Judge, I asked for count 2, trespass after warning.
Okay. Count 1, there's probable cause for possession of cocaine. It's a residue amount. That's $1,000 bond. Count 2, there's probable cause for trespass after warning, $500. Count 3, possession of drug paraphernalia is $500. Count 4, resisting without. A minute. Is $500. Have a good day, sir.
Count 5,
Oh, there's a count 5.
Yeah.
1 second.
possession of cannabis,
That will be what you want, an ROR, $1.
$1.
All right, so it's 1,000 count 1, 500 count 2, 500 count 3, 500 count 4, and $1 count 5.
I do have the officer logged on Ms. Cruz's case.
Okay, have a nice day, Mr. Day. Thank you. Let's recall the case for, what did I do with it? Oh, I'm sorry. Erica Cruz? Is that the one? Okay. Can you promote the officer and I'll swear him in?
So officer, you got to accept the promotion to a panelist, please.
Hi, officer. Raise your right hand to be sworn, please. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
Yes, I do.
Thank you. Go ahead, state.
All right, so
What is your name and what is your police department?
Jordan Nadelman, Miami-Dade Schools Police Department.
Thank you.
All right, so count 1, she was charged with exhibition of the firearm. Did she actually take it out?
No, it's going to be possession of weapon on school grounds.
Okay. And what part of school grounds did she have the gun?
She had it outside she had it inside her purse, but she walked inside the building, inside the campus.
Got it. So the victim never saw a gun?
The victim never saw a gun.
Got it. And the aggravated battery, that's for the car?
That's for the vehicle, yes.
Okay. Did the defendant intentionally hit the victim with the car?
Due to it just being a minor bump, I don't believe she intentionally struck her with the car. But per the victim was struck with the car on her left side.
So
I don't believe it was done with malintent, but it was still
did she
striking
mean to
her.
hit the victim or it was an accident?
I believe it was an accident.
Okay, I don't have any more questions. But I'm sorry, I just want to see, but in your A form it said, let me see. Per the victim, it was intentional, correct?
Right, per the victim. Correct.
And the victim believes it's intentional, why?
Because they had just had an argument over traffic, and that's when that occurred. So that led the victim to believe that it was intentionally. It could have been intentional, but there was no injury. So it's one of those that I put in as a battery.
No, you put it in as an aggravated battery.
Aggravated battery, correct, because she was using the vehicle.
The issue is whether or not the defendant intentionally hit the victim with the vehicle.
Right.
Okay.
Ms. Cora, do you have any questions?
Yes, Officer Nadelman, was a gun in the purse on campus?
Yes.
Did you see her go inside the campus with her purse?
She was walking out the campus with her purse.
And how do you know the gun was inside? Were you able to see it inside her purse? Or
I
did you
wasn't
stop
able to.
her?
No, I didn't see it inside her purse until I had her purse. But she was walking away from the campus because she did leave her son or her daughter on the school, inside the school.
And was she arrested right after walking out of the campus?
Yes.
Okay. And so she didn't have a chance to go to her, did she have a chance to go to her car first?
No. Her car was parked on the outside.
Okay.
So Judge, I understand that based upon the officer's testimony, there's an issue on the battery, whether or not it was intentional. But there's PC for possession of a gun on school property. And this is a very serious offense in that she threatened to shoot another parent before she entered the school with a gun.
One other thing, was there any damage to her vehicle? Sir?
No, there wasn't.
Okay. All right. So count one, there's probable cause for possession of a firearm on school property. That's a third-degree felony. And did you walk inside the school property itself to bring the child into the school, or was it just the entrance where you dropped off the child?
So I didn't see her walk inside the actual building of the school, like the front door of the school, but she was dropping her child off on campus, if that makes sense. Not inside the building itself, but right outside where she was dropping off her child.
You mean in front of the school where they have the gate and the fence and they have a security there?
She was inside the gate.
Inside the gate?
Yes.
Okay. Okay. So there's probable cause for count one, possession of a weapon on school property. It's pretrial services alternate bond, $2,500. You cannot bring a gun onto school property. Count two, the assault, there's probable cause for that. That's a $250 bond. And count three, there's no probable cause for aggravated battery. It's an accident, release outright. So ma'am, I don't know what happened there. Obviously, hopefully things go better your next week, dropping off your child to school. Just stay away from the victim. Thank you for coming in, officer. All right. She can get out for free with pretrial if you want to wait and give me your information.
Pretrial is over state's objection.
Okay. Thank you. Next week.
Okay, friends, we're going to change it up a little bit. I'm going to put us in the Wayback Machine. This was a hearing earlier today that happened in Stacia Buchanan's courtroom. That's in Lansing, Michigan. Just a heads up, there was an assault that took place, and pictures are shown of the injuries. And I am not going to remove them because the court put them out there for public consumption. And generally my view is if the court puts it out there, I'm going to put it out there. But just a heads up, if these kind of things bother you, go stare at your bingo card for a couple of minutes. But let's take a look at that hearing.
I do, please.
All right, Mr. Smith, I told you your lawyer would be with you in a minute. He's fast. He's right here ready to speak to you. Oh, there's Freeman. Mr. Freeman, I have Mr. Davis on Polycom. I also apparently have Mr. Swilly in the waiting room. Do you need to speak to either of them? You're muted, so if you can hear me, I can't hear you. All right, let me just connect Mr. Anthony's Polycom here. Okay, Mr. Freeman, do you need to speak to Mr. Davis?
No, Your Honor, thank you.
You'll be ready to go? Okay. All right, Mr. Davis, told you your lawyer would turn up in a minute or two, and here he is. So let's see. On the record in State of Michigan versus Dean Everett Davis Jr., 2502389FY.
Sorry. Good morning, Your Honor. Assistant Prosecuting Attorney.
Oh, go ahead.
Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Public Defender, for and on behalf of Defendant Mr. Davis.
Thank you. And you said you are Dean Davis Jr. on the video?
Yes, ma'am.
Thank you. Today's the date scheduled for our probable cause conference. We have a preliminary exam currently set for August 22nd at 10 a.m. Have we decided what we're doing about that hearing?
The defense would like to go forward with the hearing if we could, Your Honor.
Okay. Mr. Freeman, you said you want to leave it on for hearing. Mr. Pfeiffer, you started to speak. I didn't quite catch what you were going to say.
Same sentiment, Your Honor.
Okay. Leave on for preliminary exam. Okay. Preliminary exam is set for August 22nd at 10 a.m. We'll leave it on for that time. It will be in person. Mr. Davis will get you brought over for in person for that particular hearing. Remember that you have a no contact order that applies even when you're in jail. You should remember, of course, no contact with Miss Iwahara, and that applies even if you're in jail. If you're messaging her or talking to her on the phone, the prosecutor can listen to your calls. He can use your calls against you. He can use your calls to add additional criminal charges. You can also face contempt of court for violating a court order. Contempt of court is punishable by 93 days in jail and or $7,500 in fines consecutive to that which you already face. Anything else we need to address for the record for Mr. Davis?
Yes, ma'am.
Two things, Your
Yes,
Honor.
ma'am.
Hold on, Mr. Davis. I'm asking the lawyers. Go ahead, Mr. Pfeiffer.
Two things. First, I think yesterday, or I think it was yesterday, 10-page supplemental report was uploaded detailing the litany of calls that the defendant has made from the jail in just the brief time he's been in there to the victim and to talk to the victim through his father, where he not only confesses to assaulting her, but also says over and over how she comes to court, he's going to go to jail and he'll kill himself. And then also he's going to have to spend all his money that he was going to spend on her on legal fees, and therefore she just needs to not come to court so she can get that money. So we're going to be adding charges of witness interference and bribery at the exam. I believe in the misdemeanor case, his phone privileges were already revoked, but I'd like that to also be in order for the felony one, just to cover all bases. And then the second issue is that at his arraignment, he was remanded by Judge Simmons because the defendant kept having outbursts. And so I didn't know if the court felt necessary to address bond today or to address it at the exam after the testimony.
Can I speak?
No, Mr. Davis, you have a lawyer for a good reason. Do you need to speak to him?
He never came and spoke to me, so I would like to speak on my own behalf, I guess.
No.
That's not a good idea, Mr. Davis. It's not a good idea.
Oh, well, why haven't we spoken, Mr. Freeman?
Well, we're not going to discuss that right now in public. I'll come and see you before your exam, I assure you.
Okay, well.
That's it. That's it. Just hold it.
Can we address a low cash 10% assurity bond, please?
You can ask, but it won't be low, Mr. Davis. All right, go ahead, Mr. Pfeiffer, on bond.
Yes, Your Honor. Before all the jail calls, the people filed a bond form requesting $250,000 cash surety due to the defendant's significant criminal history and the level of violence here. This court knows what type of cases I exclusively work on. So when I say it's some of the worst injuries I've seen on my cases, I'd like to think that holds some weight. But I would like permission to, as an offer of proof, share screen at the moment.
Oh, I have to give you permission. Hold on one second. I have it locked down due to, how people behave on Zoom.
I remember.
Okay, let's see here. Oh, that's not working. Let me try again here. Advanced sharing. Share. Oops, one participant, all participants. Okay, I think you'll be able to do it. Let's see how it goes.
Yep. Thank you. That's what her face looked like after she was able to escape from the defendant, who had
There was
been
no escape
holding her
there.
against her will. And
Pfeiffer
again,
is just so conniving.
Mr. Davis, you really should be quiet, young man. Really.
Mr. Davis has now been muted for his own protection, as he doesn't understand he has a right to remain silent and that he may be incriminating himself. Go ahead, Mr. Pfeiffer.
and again, these are the injuries that he has confessed in jail calls to assaulting her, unless someone else also then did this afterwards. But they cover her whole body, and they are extensive. He beat her so badly he damaged his own hands. All this is while on bond. And at his arraignment, he confessed to living with her and her being there that day. Now, the people requested $250,000 because of that, because my office is very worried that he'll kill her. Just point blank. And then, almost immediately, he is calling her through his dad to have the dad send messages to her, then calling her directly, and then using other inmate accounts to call her in order to, in his own words, avoid detection. The likelihood of conviction here, from the people's point of view, is almost a certainty because of the injuries in the defendant's own statements. He is facing numerous life offenses and will be adding an additional discretionary consecutive life offense for the witness interference bribery. I am asking for $300,000 cash surety. I think that that is appropriate for this defendant based on not only his actions that led to him being arrested the first time for the misdemeanor case, then the actions led him being arrested for this case while on bond, but also his actions while in the jail in only, what, a week, 2 weeks? It's by his own hand.
Mr. Freeman, do you wish to respond?
Well, it's probably all my fault for not having gone out to the jail to see him yet. But besides that, I have known Mr. Pfeiffer for quite some time, and his testimonies in open court on the record are not one bit impeachable. I respect everything that he has said to the court. I have reviewed the photographs that he just showed in addition to others, and he's not exaggerating. So on the one hand, I'm supposed to be a public defender and I'm supposed to be a zealous advocate on behalf of my client. But on the other hand, when the truth is looking you right in the face, it's hard to, I'm not going to object to the motion for bond.
Bond is a matter of trust oftentimes for the court, trusting that the person is going to follow the bond conditions. It is alleged that Mr. Davis was on bond for domestic violence offense under a court order to have no contact with Ms. Iwahara, when it is alleged that he violated that trust and the order of the court by having contact, and not just contact, but violent contact. The bond in this case is set at $500,000 cash surety subject to the following conditions. Of course, Mr. Davis must attend all court dates and keep the court apprised of his address and phone number. The current address we have is the one on Burkhart and Howell. Do not leave the state without permission. Do not commit crimes on bond. Do not possess firearms or dangerous weapons of any sort. Do not consume or possess alcohol, marijuana, or illegal drugs. Do not engage in any assaultive or threatening behaviors. Report to pretrial services the first business day following your release. No contact with Austin Iwahara. You're not to be within 4,000 feet of where she lives, works, or goes to school. That is 4,000 feet. Further, there will be a GPS tether with house arrest and victim notification if possible. House arrest means you may only leave your residence for court and emergency medical treatment and to meet with your lawyer. If you violate the order of no contact, any bond, this very large bond, if posted, would be revoked. You'll be returned to jail without a warrant. You could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines consecutive to that which you already face. This order is about you, it's not about her. If she's texting or calling you, she's allowed to do that. If you text her back or take her call, you go to jail. She doesn't have authority to grant you permission to violate the court order. If she reaches out to you, invites you to meet her and you go, you still go to jail. Any manipulations or efforts to somehow try and use financial means to manipulate the witness can result in additional criminal charges, as it sounds like that may happen to you, Mr. Davis. We are going to have this hearing in person August 22nd, 10 a.m. If you post this bond, you do need to be here in person August 22nd, 10 a.m. And no, Mr. Davis, I'm not going to speak to you today because you don't seem to understand the rules of court or the fact that you could be incriminating yourself. Anything else for the record for from the attorneys today?
Not from the people, Your Honor.
Nothing else, Your Honor. Thank you.
Okay. Mr. Freeman, do you want to have a breakout room with Mr. Davis now, or are you going to see him? You have a date scheduled already?
Yes, Your Honor. I would very much enjoy meeting the gentleman face to face. I'll go to the jail. Thank you.
Okay, thank you very much. That will conclude today's proceeding.
Okay, so Ashley asked in the chat if there should be a bond, and the answer to that, unfortunately, is yes. The courts have ruled very consistently that unless it is a serious, like, first-degree felony, like a murder, you're entitled to a bond. Now, I showed this hearing not for the photographs. I want to make that clear. I showed it for a couple of reasons. Number one, because of the fact that it was so egregious that even the public defender kind of bailed on this guy, which kind of says something, and it's not something we see very often. He didn't even really try. That's kind of where he's at with it. And as well, I don't know if you noticed, but the prosecution asked for a $300,000 bond, and Judge Buchanan set it at $500,000. So she even went above and beyond what was asked. And it was those two things that really caught my attention and not something that we often see. So that's why I brought that to you. Let's change it up. We'll go to Florida for Wade Mercer.
Like in the terms of your state probation or community control. Ms. Tucker, I have a copy of the warrant in front of me, and it's a no bond warrant signed by the circuit judge. Ms. Tucker, when we have these situations, what I'll do is I'm going to go ahead and get you arraigned, because if you want a lawyer appointed, I want to get them appointed as soon as we can so they can be aware of your case. Ms. Tucker, would you like to have an attorney appointed to represent you?
Yes, sir.
Okay.
Yes,
I'm going
sir.
to ask that you listen to Mr. McDaniel, and then we'll see if you have any questions in just a moment.
Your Honor, we're going to enter a plea of not guilty as set this in the September 2nd trial docket, and I've already advised her, Mr. Green, to come by and talk to her prior to that hearing.
Thank you. Ms. Tucker, September 2nd. Mr. Green will see you before then. Mr. Mitchell, anything from the state?
Is that 22nd or 2nd? I think he may have cut out. Oh, it's the 2nd?
September 2nd.
Oh, okay.
All right. Ms. Tucker, any questions?
No, sir.
All right, ma'am. Have a good day. Wish you the best.
Thank you.
Yes, ma'am. We have Tony Shoemaker next. I'm sorry. Toby, not Tony. Good morning, sir. You're here for first appearance accused of one count of burglary of an unoccupied structure. I have read the complaint. There is probable cause. The criminal history that I've been provided is mostly older stuff, but what the pretrial release sheet from the jail is not filled out at all. So my question is, are you employed, sir?
No.
Okay, and you live in the Alford area?
No.
Silver Lake?
Silver Lake.
Yeah. Okay. Let me see if the attorneys have any additional information before I address your line. Mr. McDaniel, anything?
Nothing, Your Honor. I mean, I read the complaint. I didn't see much of, I guess older out of state criminal history, but yeah, it's kind of weird, but we just asked for some kind of release option.
Thank you. And I agree. The stuff I see is older, and only one thing in Florida in 2004, and that was a misdemeanor, it appears. So, Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Schumacher, I'm going to set you a standard bond of $5,000 cash or surety because it is a felony charge, and because there's no indication that you have reliable employment or consistent employment. Those are some factors I like to look at. So it's a $5,000 bond. That means you don't have to come up with all 5,000. It's cash or surety, sir. You can go through a bondsman. So let's say a bondsman charged you 10%. It would cost you then $500 to get out, but that amount's negotiable between you and the bondsman. You do have a condition to have no contact with the alleged victim or the property. You can't go back to that property, can't go to that property that you're accused of going to. Sir, you also will get to use the phone in just a few minutes to try to post that bond. Do you have any questions?
No, sir.
All right, sir. Wish you the best.
All right, thank you.
Yes, sir. And Christelle Simpson, Sergeant, find out anything on Miss Simpson?
She's been released, Your Honor.
All right, great. So Miss Simpson was an ROR warrant. So that's why she's jail released her once they verified that. Christopher Johnson, Mr. Johnson, good morning. Mr. Johnson, you're here because you've been accused of 1 count of misdemeanor battery. Mr. Johnson, I have read the complaint in your case, and it appears to me that you're on probation for 2 different case numbers already. You're still on probation, right, Mr. Johnson?
Yeah, but yes, sir. But
I'll give you a chance to ask any questions in just a second, but I don't want you to say anything that's going to hurt you. So let me tell you what I'm going to do, and then we'll see if you have any questions. On bond, on the new charge, Mr. Mitchell, anything?
No, Your Honor. I just need those 2 VOP cases.
Sure. So, Mr. Johnson, the new charge is battery. That's a misdemeanor charge. Your bond in that case is $5,000 cash or surety. That's the bond I set for someone who has a battery charge and is 99% of the time at least someone who has a battery charge and is already on probation. Mr. Mitchell is on probation in 21235 CF and 24151 CF. Both those are Jackson County cases he's on probation for. Mr. Johnson, I'm going to hold you 10 days. And the reason we do that is to get, actually, we started a new process of 7 days. And Mr. McDaniel and Mr. Mitchell, I haven't even told y'all that. That came out of our judges meeting Wednesday. So I'm going to hold you 7 days. I'm going to ask Mr. Mitchell to notify the probation office of that 7-day hold. And we'll see if they get a warrant or not. I'll see you in 7 days. If that 7 days falls on a weekend or holiday, I'll see you the next working day. It should not, though. Mr. Johnson, the judge may not issue a warrant. The judge may give you notice to appear on that. If he or she does, I'll see you the next working day after we find out about that. It's also possible the judge will issue a no bond warrant, and it's also possible the judge will issue a warrant but put a bond on it. All those decisions will be made by the judge in the VOP case. So I don't want you to talk about the charge, but if you have a question, and if it's a question I can answer, I will try.
Sure.
You have any questions?
yes, sir, man. That other probation was already terminated, man, when I was at rehab. So it got terminated and they released me from rehab. I'm on a fresh 5 years probation right now. The 3 years already been terminated.
Okay, where I'm getting the information from is the Department of Corrections website. So are you saying you're only on probation in 1 case and not 2? Is that what you're saying?
Well, at first it was 2, but they terminated it, man, while I was in rehab at Promised Land. So they released me because they put rehab on that 3 years paper and it run out. I said, run with this 5 years paper I got. So I'm on fresh 5 years. Yes, sir.
Okay, so you think you're only owning the 24 case number, not on the other ones? Is that right? You're saying?
Yeah, I'm on this new 5 years probation. So all I got is 5 years probation. I ain't got 3 no more. That was terminated in Crawfordville.
Okay. Thank you for that. So Mr. Mitchell will notify them, and then they'll.
Okay.
If they file an affidavit, they'll file it in the case number they're showing you're still on for. Mr. Mitchell.
Your Honor, the 24151 CF is a possession of controlled substance for methamphetamine.
Yes,
we're just seeing if it's possible he be drug tested.
I did ask for that. And I apologize. Thank you. Anytime someone's on probation and they have a new arrest and it's even remotely possible there may be drugs involved, I'll ask for a UA, and I didn't. So, Sarge, did y'all get a UA request?
We did one. He did fail the drug test.
Sarge, you had results of the drug test?
Yes, Your Honor. He failed for methamphetamines.
Okay. So, if y'all send an email like you do, Corporal or Sarge, I'm not sure who that was talking. If you'll send that email, Corporal, please, to Mr. McDaniel and Mr. Mitchell, then Mr. Mitchell will forward that email to probation so they can be aware of that. So, Mr. Johnson, I'll see you in 7 days, okay?
Okay.
Thank you, because when I saw it this morning, I asked Mr. Goodson it shows how quickly I forget. I am old.
That's convenient.
And mature and wise with short memory.
I was about to say.
So, Corporal, that's everything I had on my list this morning. Anything else from the jail, sir?
Go.
No, Your Honor, that's it.
All right, short docket with Wade Mercer this morning. Let's go back to Judge Glazer for a little bit.
Defender's office for you. So he's going around South Beach, 8th Street with a rolled marijuana cigarette in his right hand and a cut water lime margarita 12-ounce alcoholic beverage in another hand. 12%, 12.5% alcohol. Okay, there's probable cause. You got a place to stay, sir?
Yes.
Pretrial services, listen, you can't drink in public and you can't smoke marijuana in public. It's a crime. Pretrial service.
ROR, Judge?
How long has he been in Miami?
He's from Pennsylvania.
Been down for about 2 months.
Where'd you live before that?
I moved down here from Philadelphia.
He doesn't qualify for pretrial.
He's currently working, Judge.
Okay. Does he have priors out of Pennsylvania?
Nothing I'm aware of.
I'll release you on your own recognizance on count 1 and count 2. Make sure you keep all future court dates. If you miss court, the judge will issue a warrant for you. This is not Pennsylvania. The police here will arrest you for smoking marijuana in public and for drinking in public. If you come back and pick up a new law violation, you can be locked up in jail until your trial. Okay? Have a good day. Next is Fernando Ortiz Santana. 8-7.
Hi.
Good morning, sir. You were arrested for retail theft. I will appoint the public defender's office for you. So he goes into the Miami Optical Boutique, which I think, isn't that the River Center here?
Yeah.
She's interested in purchasing Fendi and Gucci sunglasses. And while she's speaking with the clerk, he picks up both pairs and leaves, runs out of the store. The store clerk pursued him on a scooter. All right, so when one of the managers grabbed him by the shoulder, he jerked away, causing the manager to fall down the stairs and lose consciousness. During the struggle, he dropped his cell phone and bag before fleeing. I think it's a strong arm robbery, not a retail theft. It is a retail theft, but also a strong arm. Value of stolen merchandise was $1,198. Sir, you are ordered to stay away from the Miami Optical Boutique at 1440 Northwest North River Drive in Miami, Florida. You are not allowed to go to that location. You must stay away from there. And I'm setting a bond, $7,500. Somebody was going to pay him $100 for each pair of sunglasses. You want me to do house arrest? This is very concerning. The victim ran after him and fell after grabbing him and lost consciousness. And somebody's paying him to go in these locations to steal. I don't know, state. Do you see your priors anywhere else?
But she currently lives in Camilla's house.
$7,500 bond. Stay away from that business. Good day, sir. Went back to the store with wearing a different shirt, claiming to be the brother of the person who stole the glasses and wanted his cell phone back. You can't make this stuff up. Let's hope the manager was okay. Anyway, next we have is Zacchaeus Beinskinner on page 8. Is he there or is he still refusing?
We need to pass it for now, Your Honor.
Okay, next we have is Rolando Sanchez Turan on page 9.
Spanish, please.
Good morning, sir. You were arrested for grand theft, a second-degree felony, and contracting without a license.
Your microphone is off?
I know, I'm
Thank
trying
you.
to
Sí, muy
speak privately with
buenos
my
días.
bailiff.
No, not you, Judge, the Spanish
No, I believe,
interpreter.
yeah, I believe she meant the interpreter. Yes, sorry. Sí, se le acusa de robo mayor, señor. Robo mayor con intención es la acusación.
So it's a case from December 1st of 2023.
Es un caso del 1 de diciembre de 2023.
So he was paid 3 separate payments totaling $33,000 and never performed the work pursuant to the contract.
Le hicieron 3 pagos, un total de $33,000 y nunca se hizo el trabajo pertinente al contrato.
There is probable cause for the charge.
¿Hay causa probable de estos cargos?
You are ordered to stay away from the alleged victim, Sonia Byers.
Se le ordena a que se aleje usted de la víctima, Sonia Byers.
No contact with the victim, either directly, indirectly, in person, in writing, by telephone or through third parties.
No debe tener contacto con la víctima, ni directa, ni directamente, ni por teléfono, de ninguna manera, ni por medio de terceras personas.
No contact with the victim through social media or other electronic means.
No contactar a la víctima en redes sociales, ni en ninguna otra manera de comunicación electrónica.
And you must stay at least 500 feet away from the victim's home and school and place of employment at all times.
Y debes permanecer por lo menos a 500 pies alejados de la víctima y de la casa y escuela de la víctima o lugar de empleo en todo momento.
Do you understand the stay away order, sir?
¿Entiende usted la orden de alejamiento?
Correcto.
Correct.
Okay, I'm setting a bond, $7,500, count 1, 500, count 2. Have a good day.
I'm looking to see where it says he didn't have a license.
Thought I read that.
Si le fijo la fianza de $7,500 por la acusación 1 y 500 por la número 2.
Let me see.
It says they filed a complaint, but it didn't state he did not
Doesn't
have-
say he didn't have a license. He ceased all communications after he received the payments. You're right, it doesn't say that. So do you want me to reset it for probable cause hearing or?
Or dollar on count. Oh, I'm sorry, Judge. You're
Release
right, that's
it,
just on count 2.
Count 1, there's probable cause, release outright, count 2, no probable cause.
Okay, por la primera hay causa probable, se le pone libertad, la segunda no hay causa probable.
Good day, sir.
I'm sorry, Anna, can
Que
you
tenga
repeat
usted
the
buen
one
día.
again?
$7,500, count 1 for grand theft, is second-degree felony. No probable cause for count 2, contracting without a license, so it's release outright for count 2.
¿Y
Diana.
$7,500? Sorry.
Diana, permite the
$7,500?
bond in there.
Please
So,
let the
Mr.
correction speak. What?
No, I thought he was done already.
I don't know. I keep interpreting. I don't know, and I can't hear you, and I can't hear him. So now I can hear everybody.
Yeah.
Lee.
Austin, congratulations. Bingo number 3 for you. You are our first 3-time winner. Good news, you won absolutely nothing, but I'm sure you had fun, and that's what the whole reason it's there. So yeah, if you guys aren't playing along, go to the pinned chat, tcfbingo.com, and you can play along as you watch along with Court. It's a fun way to pass the time, as I'm sure Austin will attest to.
Now we have Lee Jenkins on page 9. Hi, Mr. Jenkins. Good morning. You were arrested for uttering a forged instrument or check forgery, and grand theft. And I will appoint the public defender's office for you. So it's from January 28th of this year. He went to the check cashing store and gave his ID, cashed a check for $983 issued by Seaboard Marine, and that they were notified the check was counterfeit. So that's what's happening. There's probable cause for the charges. He says he didn't know, he remembered cashing it, didn't know it was stolen. Anyway, there's probable cause. He was also paid $500. He paid the other person $500 from the proceeds of the check. Yeah, usually when somebody gives you a check to cash and wants part of the money from it, you're gonna get pretty guess there's a problem. Guess there's a problem with the check. Does he have priors? He has a lot. Signal. I'll set a bond. Count one.
Would you consider tap, Judge?
No, I don't think so. Not.
Bad check for doing work from somebody. I mean, I don't know if this is even gonna
Yeah.
file in this case, Judge.
Why not? He stole our money.
You have to have knowledge.
I had no knowledge. I didn't steal it, man.
When you cash a check and you gotta give somebody half the money or more than half the money, yeah, that's an issue. State, what do you want?
Up to you, Judge, on tap.
Okay. Do you have a place to stay, sir? You have an address? All right, tap alternate bond, count one, $2,500 for uttering a forged check. Count two, check forgery is $2,500, and count three, grand theft is $2,500. Make sure to keep all future court dates. Next we have is Eduardo Valdez, page 9.
Well, let's change it up a little bit. There's not a whole metric ton of court going on today unless you like landlord-tenant. But Judge Elmore does have some stuff going on. So, and he's in Misaki today. So let's go there.
I'm going to begin by asking, do you have a resolution today?
Judge, we do not have a resolution. I have communicated with Mr. Denhoughton. My understanding is at this time there is no formal plea offer, that they're still waiting on some information to come in. Additionally, we have requested that the two weapons that are alleged to be involved here be sent to the lab for DNA and fingerprint analysis. Mr. LaRoche is consenting to providing DNA and fingerprint samples to facilitate that. I have requested a copy of the transcript from the preliminary examination, but have not yet received it. The exam was just about 2 to 3 weeks ago.
All right. I'll make a note here. I'm pretty sure the court reporter is making a transcript, but I'll make sure a note is added here for my staff to double check later this afternoon. Obviously, no motions yet because we haven't, the parties haven't received the transcript. And of course, there are some discovery issues being addressed as Mr. Roop just discussed. Anything on behalf of the people, Mr. Denhoughton, I should note?
I would just indicate that I would acknowledge that there's been a request for some additional testing. I expect that we'll have a stipulated order submitted, and that will be, I'll facilitate that within the next week or so, Your Honor.
No worries, no problem. Mr. Rook, let me know if you have any issues. And same thing with Mr. Denhoughton. If we need to adjust timelines because it takes a while for the lab to get the work done, please just let me know. If you all are having any problems with the lab, also please let me know.
I will do so.
Mr. Roche. All right, thank you. Mr. Roche, as you may know, a pretrial conference is just that. It's just a conference so I get an idea of what's going on with the case. And if I need to step in and be involved in something. It sounds like right now there's nothing for me to do other than to wait for you all to tell me, Judge, we need you to do something. So right now, there's nothing that we need to be worried about. I'll also note for all those present here, and it's very common that parties exchange offers and pretrial offers and things like that. That doesn't mean that there's any statement as to whether or not there is guilt. It's just that's what generally happens. So that way you get to make choices. All right. Anything further today, Mr. Denham?
No, Your Honor.
Any questions, Mr. LaRoche?
No, Your Honor.
Anything further today, Mr. Roop?
No, Your Honor. Thank you.
All right, folks, thank you all very much for your time. Unless I see you all for a motion, the next time we'll see each other should be on the date for the final pretrial conference. Thank you. We are adjourned.
Thank you, Judge. Thank you.
Our next file this morning that we're going to take up on the docket is people of the state of Michigan versus Gregory Edward Zachary. This is going to be case number 25-3625 FH. We're just going to need to get defense counsel. She may be out speaking with somebody else in the jail. Sir, are you Mr. Zachary?
Yes, I am, Your Honor.
All right, so that's your table over there. You're on the seat furthest. Nope, one more.
I'm sorry.
There, it's all right. No, you're fine. There's nothing to apologize about. I'm just telling you that that's where the attorney will want to sit. So again, Mr. Zachary is here, and we have Mr. Rickstrom. No, did you say? Yeah, you were. All right. Thank you. All right. All right. The court also recognizes now before it Ms. Taylor and Firavento. I know this morning we've got quite a docket today, and so Ms. Firavento, I know, is running around between the jail and the lobby trying to meet with all of her clients. We are here today on this case for a pretrial conference. I conducted that in chambers with counsel. Counsel informed me that they anticipate a resolution of the case and that we will potentially enter a plea this morning with the understanding that there will be a referral to sobriety court. 1 second.
Sorry, the prosecutor just asked me a question
Sure.
when I walked in the courtroom on
It's okay. Go
new
ahead.
issue.
Take your time.
Your Honor, the people are anticipating a plea in this, and that plea would be to the defendant pleading to OWI 3rd as a killer agreement with sobriety court. And then after 1 year, it would go down to OWI 2nd if successful. The question that I was posing to defense counsel, and I will leave it up to her what she wants to do. The blood draw that occurred 3 hours later was actually a 0.077. We do have other means to be able to say that he was drinking and driving. I was just going to ask whether or not she would stipulate to the PBT at the time.
Well, hold on. If you need time, first of all, there's no rush today, okay? We're here for an initial pretrial conference. If we're able to take a plea and resolve a case, that's great. If we can't, that's fine as well. If this is something that you wish to look into, Ms. Firavento, you can. A PBT is generally inadmissible. So if this is something you wish to look into, I think that's appropriate on behalf of your client. All right, do we wish to just pass it and have it continued for a final?
Could we do that, Your Honor? Thank you.
I think that's appropriate. Also, if there is an application being processed for consideration to be referred to sobriety court, this gives time for all that paperwork to catch up. All right, so let me just ask this, any other motions or discovery issues?
No, Your Honor.
All right, Ms. Firavento?
Not at this time, Your Honor. Would the court want to go ahead and just set this out for another hearing then and then
Nope.
the idea of pleading at
But-
that point?
No, let's do it. Well, yes and no. We're going to leave it set for the hearing that we already anticipate, which is and is already set, which will be the final pretrial conference. If the parties wish to bring the case before the court earlier, whether it's for a motion or something else, or to enter a plea, you all can just contact the office and get it placed on the docket in a way that meets everybody's time schedule. But otherwise, I want to leave it up in the air and give you enough time to do all your other work, plus this particular file, and the question on the file. All right. So far, no other motions or discovery issues. Mr. Zachary, nothing's going on bad today. We're just here for a conference. If we can resolve it, great. If we can't, no worries. The court has no position, right? I got no dog in the fight, so we're gonna pass this, which by the way, happens with most of the cases on a pretrial conference day. This is really just a day for me to find out where this case is going and where to put it in my docket, and then to make sure the attorneys are doing their job. It sounds like everything's working fairly smoothly. I said the word fairly. I didn't mean to do that. Things are working smoothly. All right. Bond conditions continue. Mr. Zachary, I don't see any, the folder, the file here is not getting thick, which means I don't have any issues or allegations that you're violating bond. Just make sure you remain compliant with bond. If someone violates bond, then I can always modify it, or I can revoke them and put them into jail. And I'd really rather not do that. All right. Any questions for me today, sir? All right. Thank you all very much for your time. We are adjourned.
Let's go back to Florida, check in with Judge Glazer. We are getting closer to lunchtime, so let's see how she's holding up.
Media or other electronic means.
No contactar a la víctima por redes sociales ni ningún otro tipo de comunicación electrónica.
And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times.
Debe permanecer por lo menos 500 pies de alejamiento de la víctima del lugar de escuela, trabajo o casa de la víctima.
Count one, there's probable cause for aggravated battery. It's a $7,500 bond.
Acusación número 1, hay causa probable por agresión agravada, válgame lo así, son $7,500 de fianza.
Count two, culpable negligence is $150.
Negligencia es $500 en la segunda acusación.
Good day, sir.
Que tenga buen día.
Next on page 10, we have Jean Prudent. Bond out. Bond out. Adrian Brown is next. Good morning, Mr. Brown. Well, you got a bunch of cases. You were arrested for 13 cases. Looks like they're theft cases. So we'll go case by case. Petty theft, 2 or more convictions. Also, you're out on felony bond. There's a hold for case F255936 and F296014A. So the public defender's office is appointed for you in all of these cases. We'll start with F25-17598. This is a petty theft, 2 or more convictions from June 11th. He's seen entering the liquor store by the Martinez food distributors. He took 4 bottles of Tito's vodka and then left. He has prior convictions. So you are ordered to stay away from the Martinez food distributors at 18901 South Dixie Highway in Cutler Bay, Florida. You are not allowed to go to that location. You must stay away from there. The bond on this case is $2,500. Next case, F25-17569, that is from yesterday, August 14th. You're charged of petty theft, 2 or more convictions. So he stole over 30 pieces of clothing with price tags still attached from the Kohl's store. Oh, some had the Kohl's store. And another 20, also with the hangers.
I don't
Yeah,
think
25.
a prior grand theft auto charge,
Yeah, that's what it was.
It says he has multiple theft convictions.
but the 1996 case is a
Hard to.
part of a grand theft auto, and let me
Wow.
see, F24.
Does he have priors out of county as well?
Give me a second.
He has petty theft. January 31st, 2025, he has 3 days for petty theft.
Everything's local.
Really? But I'm not supposed to rely on these, right, Ms. Corey, or is it only when it's
Correct.
benefits your client?
Well, I mean, the one
he
he lists the cases, Judge, and the one is a grand theft auto.
Yeah, no, you're right.
Does it not?
There should be.
I don't know if it
But let me
includes
see the
grand
pattern
theft.
on it. Let's say. Ms. Corey, are you saying you know it doesn't count?
No.
I'm 90% sure.
All right, I'm gonna look it up.
Okay.
Okay. So we're trying to determine if the grand theft of an automobile could be used to enhance the petty theft charge to be petty theft 2 or more convictions. I think Ms. Corey may be correct. Anyway, sir, in this case, you're ordered to stay away from the Kohl's store at 11800 Mills Drive in Miami, Florida. You're not allowed to go to that Kohl's store and you must stay away from there, sir. Okay?
All right, so here's the actual statute.
Can I have that last one back? Did I give it to you or no? I still
Alright.
have it.
It's
Thank you.
3C.
Or no, the next one, Kohl's. Let's see. The
Person who
court-
commits petty theft and who has been previously convicted 2 or more times of any theft commits a felony.
So it would apply. I have it. So there is probable cause for petty theft 2 or more convictions. All right, in this case, F 175 I'll set his bond at $1,500.
Judge, what was the bond on 598, the one before?
2,500. And we have F 175 That is from July 19th, that he goes to the Publix liquor store and he's stealing 10 bottles of 1800 tequila blanco. Total value $309.90. He has multiple convictions. So there's probable cause for the charge. You are ordered to stay away from the Publix liquor store at 9105 South Dayland Boulevard in Miami, Florida. You're not allowed to go to that liquor store. You must stay away from there. Your bond is $2,500. Then we have F 17067. That's from August 10th. Retail theft with a prior conviction, so he's stealing steaks. There's multiple convictions. I don't see a value. Oh, and $710 of merchandise, steaks. You're ordered to stay away from the public supermarket at 13005 Southwest 89th Place in Miami, Florida. You're not allowed to go to that public store and you must stay away from there. Bond is $2,500. Yeah, it would be retail theft with a prior conviction. That should be a $7,500 bond. I'll leave it at 2,500. Right? Is it a retail theft or petty theft?
If you want to leave it.
I think it should be petty theft. Okay, then next is F 175 That's petty theft 2 or more convictions from August 2nd. Again, at a Publix liquor store. Stay away from the Publix liquor store at 14601 South Dixie Highway in Palmetto Bay, Florida. You're not allowed to go to that Publix liquor store. You must stay away from there. He's stealing Cheetos again, $284. Bond is $2,500. Next is F 175 That is a retail theft charge from April 28th of 2025, again at a Kohl's store, I think. Let me take a look. So he's working with his friend, stealing multiple boxes of shoes. $760 is probable cause for retail theft. The bond is $2,500. Next, we have F25-17564. With the retail theft charge from May 17th of 2025. He's stealing multiple boxes of shoes, again from Kohl's, $995.05. There's probable cause for the charge. Your bond is $2,500. Right, he had that hold? Didn't he have a hold?
Yeah.
Okay, I'm writing it in all these cases, so I hope so. What signal is he? Signal 100 as well. And we have F25-17548 from May 23rd. We went to Publix and stole 7 bottles of Tito's vodka. It's $203 and mentions prior convictions. Your bond is $2,500. In this case, okay. So. F25-17547 is petty theft, 2 or more convictions from April 28th. He went to the BJ's wholesale store, liquor store, and stole alcohol. $232 of alcohol. You're ordered to stay away from the BJ's wholesale liquor store at 16200 Southwest 88th Street in Miami, Florida. Got to stay out of that store. Bond on this case is $2,500. Next, we have F25-17546. This is from April 6th of 2020. It should be 2025. They made a mistake in the byline here. But it's he's stealing from Fresco-y Moss. $604 of merchandise. Stay away from Fresco-y Moss at 18302 Southwest 137th Avenue in Miami, Florida. You're not allowed to go to that store. You must stay away from there. It should be petty theft with a prior conviction. Bond is $2,500. Next is F25-17544. Charges petty theft, 2 or more convictions in April. It's back at a Publix liquor store in Palmetto Bay. Stealing vodka, $317. There's probable cause for the charge. Bond is $2,500. Next is F25-17543. That is from May 12th. He's stealing alcohol from the Publix liquor store. A bottle of Remy Martin Cognac for $178. And, oh, that's also with the Tito's vodka. There's probable cause for the charge. Bond is $2,500 for petty theft, 2 or more convictions. Then we have F25-17542. This is from April 17th, where he's stealing from Walgreens multiple bottles of laundry detergent. Value is $95. There's probable cause for the charge. You are ordered to stay away from the Walgreens store at 15255 Southwest 137th Avenue in Miami, Florida. And your bond is $2,500. All right, so sir, that's it. You'll see your judge Monday. Good day.
Finally, that's it. Honestly, I didn't know if that was ever going to end. I haven't been here in a while. Let's go to Adams County, Colorado, where they are doing bond hearings.
Okay. Mr. Shelby, come on up. Good morning, sir. This is 25M4365. Can I have appearances?
Dan Rosenberg appearing on behalf of the people.
Sarah Steele on behalf of Mr. Shelby.
All right, Ms. Steele, regarding bonds.
Thank you, Your Honor. Your Honor, I'm asking the court to set a lowered bond, but not necessarily a PR bond. And the reason for that is that Mr. Shelby has this Adams County case 25 CR 1870, where he is awaiting sentencing on September 30th. So I am asking the court just to set a reasonable bond for Mr. Shelby. I would note that in looking at the case, it looks like this allegation is based on a Jefferson County matter where Mr. Shelby was on probation. And it looks like the protection order there was modified according to the minute orders to allow for electronic communication regarding the child. I wasn't able to actually pull up the actual protection order itself because it's protected from Jefferson County. So I couldn't look at that, but I just wanted the court and the DA to be aware of that. Thank you.
Okay, thank you, Mr. Rosenberg.
I'm asking for $1,000 cash, surety, Your Honor. He's a CPAT-4. I'm always very troubled when people were reaching out from the jail to contact the victims because that seems so frequently to be tampering. But I don't have evidence of that here. That's why it's charged as a non-DV VPO. So I think a lower amount of $1,000 would make sense.
So can I call you?
No, just.
All right. Thank you. I'll set bond in the amount of $1,000 cash surety. Next court date will be on August 25th at 1:30 p.m. Division FAC for an arraignment. All right, good luck.
And I think I've run out of people because the last one I had was Jason Yang and he's not present.
He's not present?
Yeah, I don't know if maybe he went to the restroom. Yeah.
Ready?
Yeah, I'm ready for it. Yeah. Looks like they're getting Mr. Yang.
All right, perfect. And that was your last one, Ms. Steele?
Yes.
Perfect.
I suppose we could call someone else. While
Okay,
they're
I've got a couple PRs we could just do real quick. How about Ainsley Toppin?
Good morning, sir.
Yeah, good morning, Mr. Toppin. This is 25M4368. Good morning, Ms. Abbott. How you doing?
Good morning, doing well, thank you.
Good. And I have appearances.
Sorry, Dan Rosenberg appearing on behalf of the people.
And Olivia Abbott on behalf of Mr. Toppin, he does appear at the podium. And I'm sorry, what was the case number again?
Yeah, 25M4368.
Thank you.
Bet. All right, Mr. Toppin, I'm going to begin by issuing a protection order in your matter this morning due to the domestic violence allegations. I find this is governed by Brady, and I'll activate provisions 1 through 7. Ms. Abbott, I couldn't tell from the affidavit, it was unclear to me if he needs a civil assist or not.
We do need a civil assist, please.
Okay, and I'll authorize a civil assist. Alleged victim here, Kim Ashmore. Date of birth is 7/17/77. All right, Mr. Toppin, as it relates to Ms. Ashmore, this means you shall not harass, molest, or intimidate her. You shall stay away from her home and any location where she may be found. You may not contact her directly or indirectly. You shall not possess, purchase, or control firearms, other weapons, or ammunition, and you shall relinquish any such objects within 24 hours of your release today. You shall also complete an affidavit and file it with proof of relinquishment with the court within 7 business days. You may not possess or consume any alcoholic beverages or controlled substances. Per the request of your attorney, Ms. Abbott, I'm going to give you a civil assist so that you'll have an opportunity to go back to your shared residence with her and retrieve your personal belongings. That will be with the accompaniment of a sheriff's deputy, and it is incumbent upon you to set that up. Conditions of this protection order, sir, will be conditions of your bond. So if you violate any of those conditions, you could be subject to additional criminal or contempt sanctions, and you'll need to sign a copy of this as soon as we're finished speaking. The DA has no objection to a PR bond in your case, sir, so I'm going to grant you a personal recognizance bond this morning in the amount of $2,500. That means that you don't have to post any money to get out of jail. It's very important that you show up for your next court date. I don't see any criminal history here at all, so I assume you're going to be able to do that and get this taken care of. If you don't show up for your next court date, a bench warrant would issue for your arrest, and you'd end up back here, and you likely wouldn't get a PR bond a second time, all right?
Okay.
Next court date will be August 19th at 1:30 p.m. Division R for an arraignment. All right, good luck, sir.
Thank you.
You're welcome.
Okay, we're going to head back to Michigan and to Judge Middleton. He mentioned this the other day in another hearing, and I wasn't sure what he was talking about, but he's got something labeled Special Assignment Kalamazoo County. So it sounds like a Kalamazoo County case that got moved to St. Joseph for some reason. No idea what this is about, but let's give it a look.
Your Honor, can I address the court before we go on the record?
We're on the record. I can shut it off.
I know the court indicated that it was going to be live
It
streamed.
is. We're on the live stream right now.
I told my client that you're going to be live streaming it. I would object to the live stream. This is going to be under 769.4A. In that statute, it indicates that these hearings are public on the public record. I get that. But public record doesn't necessarily mean that it's live streamed to the world. And so I would object to the live streaming of it while we're having this sensitive plea where the file will be closed after this to the public. So I would make that objection, Your Honor.
All right. Your objection is noted. It's overruled. This is a matter of public interest. It is a public charge. She's not yet been placed on deferral status, and we're in our courtroom, and we'll go on the record.
Thank you.
All right. This is a special assignment case from Kalamazoo County. The parties here are the state of Michigan, in this case, the county of Kalamazoo. The matter was assigned as special prosecution to the St. Joseph County Prosecuting Attorney's Office, and Gary Gabry is handling the case for that assignment. In light of that assignment, the Supreme Court assigned the matter to the St. Joseph County District Court, namely me. And the matter was charged. This is Kalamazoo County file number 2501371FY, People versus Tammy Rayshon Key. That's you?
Right, yes.
Say that again?
Right.
Oh, right. I can't read my own writing. It is Ray, not a Key. Ray. I met you briefly on screen last week at the pre-exam conference. The charges here are alleged to be 2 counts of resisting and obstructing a police officer, Officer Grace Meisner of the Kalamazoo City Police Department, and Kayla Miller, also of that department. Those are felonies punishable by up to 2 years imprisonment and a fine of up to $2,000. Because they were felonies, the matter had to be set for a preliminary examination. We had a pre-exam conference. Both attorneys advised we were just going to set this for a prelim. So we worked out the logistics of me coming to Kalamazoo to hear this case. A few days later, we got a series of emails indicating that there'd been some resolution and they wanted to do it as soon as possible. I will be gone next week or much of next week for the Judicial District Court Judges Conference. So we crammed this in this morning at 11:30, and I appreciate everybody's indulgence. Met with Attorney Michael Hills, who's representing the defendant, and Prosecutor Gabry. They advised me in chambers that the prosecution intends to dismiss both counts of resisting and obstructing a police officer, the felony charges, and one count of domestic violence. The defendant would enter a plea to one count of domestic violence. As I understand it, it's a slap. And the other count would be dismissed. Prosecutors recommending that I put you on a domestic violence deferral probation. Mr. Hills indicated at that point that becomes non-public. The probation would be, I'm presuming, through Kalamazoo County, unless they disqualify also. They may have an apprehension about having their probation department handle this case the same way that the court. So that may be reason enough to set this for sentence. At any rate, Ms. Ray, the felony charges would be dismissed, and it's envisioned that you would enter a plea to one count of domestic violence against Adrian W. Lindsay, and the other charges would all be dismissed. I cannot put you on a deferral program unless the prosecutor consents. Mr. Gabry, have I stated the plea agreement correctly?
You have, Your Honor, and the record should also reflect that I did talk to Mr. Lindsay, explained what my proposal was, explained what, likelihood of period of probation and the kind of counseling that would come forward with that. And he was in agreement and does not object to placement under the statute.
All right, thank you. All right, Ms. Ray, do you understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. You've retained Mr. Hills, and that's certainly fine with us. You could have also asked to have had an attorney appointed, either under the Kalamazoo system or ours. At any rate, that matter's been resolved with you retained counsel. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. Tell your side of the story. You also have a right not to testify, and if you did not wish to testify, the judge or jury could not hold your silence against you. You'd have a right to have any of the witnesses, including Mr. Lindsay and the officers, for or against you, subpoenaed to come to court so they could be questioned under oath, and you would continue with your right of presumption of innocence unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
Anybody threaten you to get you to plead to this charge?
No.
Or promise you anything?
No.
All right. This happened in the city of Kalamazoo. Were you and Mr. Lindsay at one time in a relationship?
Yes.
And you share a child?
Yes.
How old is that child?
11 months.
All right. This is alleged to have occurred on May 23rd of 2025. On that date, were you and Mr. Lindsay in contact with each other regarding exchange of custody of the child?
Yes.
Did you and he get into an argument about a car seat or the facts of the exchange of custody?
Yes.
And did you lose your temper and slap him in the face?
Yes.
And Mr. Gabriel, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Hills?
Yes, Your Honor.
All right. Ms. Ray, the reason I'm here is because I don't know you. I know of you. Mr. Hills tells me, and I don't have any reason to disbelieve this, you've got quite an accomplished resume. You're involved in lots of things in Kalamazoo. I also don't know Mr. Lindsay. What I also don't know is exactly what the policies and procedures are of the Kalamazoo County District Court and Probation Department. I have here at my availability a probation. We have a specific probation for women. It has a women's anger management program that I actually started when I was county prosecutor, and a supervision by our probation department and a set of costs and how everything works. This kind of caught me, well, not exactly by surprise, but I was surprised by your lawyer a few days ago that this was going to be a plea. I didn't know the terms of the plea agreement till just this morning. I didn't really have time to work out the logistics of how they want me to do this in Kalamazoo County. There's also the issue about whether Kalamazoo County Probation Department is going to be recused also. We work with them regularly. My probation officers know their probation officers. I've met some of them at conferences. We're border counties. Often we have people that manage to get in trouble in more than one place. So they're a competent professional office, but I'm not sure what they want. So the upshot of all this is we have already cleared the date of Tuesday, August 26th in Kalamazoo County. I'm not sure which courtroom it is, but we had reserved that space for the preliminary examination. That will be more than 10 days from today. The domestic violence statute envisions that when there's victim input, there would be at least a 10-day delay. I think Mr. Lindsay has given Mr. Gabriel the blessing to go ahead and do the sentence today. He's written a letter, and he has strong feelings about this. The other problem, and this happens all the time, you guys are stuck with each other for the next 17 years. You're going to be parents of this child, and you're going to need to co-parent, and you're going to need to learn to get along with each other. Let me just confirm from you, you've never been previously convicted of any assaultive offense?
No.
All right, because you're only eligible for this deferral one time. And I believe that you were not, but I needed to confirm it for the record. So we're going to do the sentence in this matter at 1:30 on the 26th of August in Kalamazoo. I don't have the whole police report. The letter Mr. Gabriel gave me is quite helpful as to input from Mr. Lindsay. He has a right to be present if he wishes to be. And at that point, it's envisioned that the matter would be deferred. Now let's talk about that. Domestic violence, I didn't even state this, as it's charged as a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It would also prohibit you from owning or possessing a firearm for at least 8 years. Now that's important if you're in the military or you're a police officer. Here in our county, you have lots of people that hunt, target shoot, and it's important to them to preserve their rights to use or possess a gun. If you're placed on this probation and you successfully complete it, the charge is removed as a public record of conviction. Now they keep a private record, the state police do, because you're only eligible for it once, so they have to keep track of it, whether there was one or not previously. But what I expect is that you're going to comply with the terms of this probation and successfully complete it. But I need more information before I can make that decision. So I have accepted your plea. Both counsel are satisfied with the factual basis.
Your Honor, may I?
Yes.
You left a cliffhanger.
What?
The cliffhanger is if you complete it, then you can.
Oh,
possess
well,
your
okay.
guns.
Here's the cliffhanger. I said I envision you'll come, if you don't complete it and the wheels fall off, you're subject to a jail sentence and the matter would become public and you'd lose your rights. So our probation includes terms like no drugs or alcohol. I don't believe drugs or alcohol are a factor in this situation, but everybody that's placed on probation has that condition. It would also include a condition of no assault or threatening behavior. It would include a condition that you complete a certified domestic violence treatment program. And I'm not exactly sure what their program is in Kalamazoo County. I told you I know what ours are. And there's, I think, currently a no contact provision in place. I'd like to address that there isn't.
No, the no contact provision was not checked. We had that issue.
We discussed that at the pre-exam.
Yeah, so there's a no assaultive behavior situation so that they can, exchange custody.
You have just this one child together?
Yes, sir.
Okay. And does he also reside in Kalamazoo?
Yes,
So you're close proximity to one another.
yes.
Does the child have a primary residence or do you share custody of the child?
I would say my residence is the primary residence. We do share custody. However, his parenting time is pretty low.
All right. So the child mostly resides with you and then he has parenting time.
Yes.
All right. Again, that's stuff I didn't know and I would want to know at the time of the sentence. So we will revisit this. I don't yet know exactly which courtroom. Let me see if it's on that notice. That's the notice for today. Well, we will make sure everybody is aware of where we're supposed to be. In the meantime, I'm going to have my probation department contact their probation department and make sure that I am apprised of their procedure for domestic violence deferral sentence. Mr. Gabriel, anything further we need to place on the record?
Your Honor, I would like the record to reflect that the letter that the court referenced from Mr. Lindsay has also been provided to Mr. Hills prior to what's going on the record. So he's had an opportunity to review that. I'd also like to indicate for the record that this case was in fact charged initially as a felony under a probable cause standard. However, once I was assigned, I reviewed video footage, had discussions with Mr. Hills, and email correspondence has been had with the police department. And since there was no aggressive or violent behavior demonstrated towards the officers, and this was a highly emotional situation, we saw no reason to proceed with felonies. And by her accepting responsibility to the domestic, we certainly understand. And that's why we've made the referral or the recommendation for the deferral program. Thank you, Ron.
Thank you. Mr. Hills, anything further?
We appreciate the discussions with the prosecutor. That is all accurate, as well as I do have a copy of the letter from Mr. Lindsay.
All right, you provided me with a Kalamazoo County form, criminal pretrial statement, and indicating pled guilty to DV first with treatment as first offense DV, dismiss remainder of file. All right, very good. I'll see you all in Kalamazoo on Tuesday the 26th at 1:30.
Thank you for taking this up.
Thank you. All right, thank you. All right. I've got one more landlord-tenant matter to address. I think it's resolved, so I'm going to stop the live stream.
He stops the live stream, and we'll move on. Now we know what that was all about, though. Let's go to stay in Michigan. We'll head to the northern Lower Peninsula, Kalkaska. This is Judge Mertz.
Hey, Ms. Wheeler, are you able to hear me okay?
Yes.
All right. All right, we've got Mr. Seeger back. We've got everybody connected. So we'll go on the record now in People versus Kylie Wheeler. This is Kalkaska file number 244975. The record should reflect Ms. Wheeler's appearing by Zoom today by video from Wexford County Jail. We have Mr. Seeger here on her behalf by Zoom and Ms. Wagner on behalf of probation. This is set as a probation violation hearing today. I did receive an email indicating that there's a plea agreement that Ms. Wheeler would plead to count one of the non-technical violation. Mr. Seeger, is that your understanding?
That is correct, Your Honor, and I did discuss it with the client, and that's my understanding.
All right, Ms. Wheeler, were you able to hear that?
Yes, sir.
Is that how you wanted to proceed today as well?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Wheeler, you understand that you have the right to have a hearing as to whether or not you violated your probation, and that by pleading guilty to the violation, you're going to be giving up that right?
Yes.
And you also understand that by pleading guilty, it could subject you to the next possible penalty on your underlying charge, which is up to 4 years. Do you understand that as well?
Yes, sir.
With those things in mind, what is your plea to that probation violation today?
Guilty.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything to get you to plead guilty?
No.
Is it your own free choice?
Yes, sir.
Are you pleading guilty because you did violate your probation?
Yes, sir.
Were you on probation back on June 3rd of 2025?
Yes.
And were you aware that one of the conditions of your probation was that you were to report to your probation agent and to appear for any court hearings that you were required to appear for?
Yes, I didn't know I had a court hearing though.
Okay, and did you not know that because you hadn't been reporting to your probation agent?
Right.
Okay, and you did not appear for that hearing in June, is that correct?
Right.
All right. The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that Ms. Wheeler violated her probation by failing to stay in contact with her agent and failing to appear for a hearing on June 3rd of 2025. The court will accept the guilty plea. Ms. Wagner, based on the email, it looks like, are you going to be asking for additional jail time?
I am, Your Honor. I think our guidelines are 0 to 6 months. I believe I put maybe, I think she's got 34 days credit. Maybe I'm asking based upon her non-compliance. She didn't get into treatment. She's been given several opportunities to address her drug problem. She's continued to use. Her whereabouts was unknown up until her arrest. So I asked that additional jail time be imposed, 7411 be revoked, and that she be discharged unsuccessfully from probation.
All right, so because there's going to be, or the request for additional jail time is a possibility, the court is going to order that an updated PSI be prepared, and the court will set this for a sentencing hearing. Ms. Wheeler, you'll be notified of the date and time of that hearing, and you'll have an opportunity to go through that pre-sentence report on the violation with Mr. Seeger prior to the hearing. And Ms. Wagner will be in touch with you to prepare that report. Ms. Wagner, anything else we have to address on behalf of the probation department today?
No, if she's willing to waive her PV report, would the court be inclined to sentence her today with that verbal recommendation?
Mr. Seeger, is that something that you've discussed with Ms. Wheeler?
I did, Your Honor. She would waive a written report.
Okay, Ms. Wheeler, you understand that you do have the right to have an updated report prepared?
Yes.
And did you want to proceed with sentencing today even without that report?
Yes, please.
Okay. All right, Ms. Wagner, I think I have your recommendation. Mr. Seeger, is there anything that you wanted to say on behalf of Ms. Wheeler?
Your Honor, by way of elocution, I can't excuse what she's done because clearly there's an object to probation, and that object is for people to attempt to address some of the underlying problems that they have, and clearly she's not done a very good job of it. However, Your Honor, she does not have a long, extensive criminal history. She's losing the benefit of 7411, presumably. She's going to be discharged unsuccessfully from probation if the court follows the recommendation. If she has 34 days credit, that's time that she's already expended. Clearly, all of this could have been avoided, and hopefully, going forward, she's able to remain substance abuse free. But I think the greater punishment for Ms. Wheeler is going to be having the conviction entered on her record when it was wholly avoidable. I do recognize that she has a substance abuse problem. I think she recognizes that as well. And it's unfortunate, Your Honor, simply because, and I think the court has noted this in the past, but simply because the court places someone on probation or because there's a condition of bond that people not use drugs. When you have a substance abuse problem, it's probably not as easy as that, even though for you and I, that's a very rational thing to do. I think that she was struggling in life. She was not necessarily making good decisions. She recognizes that she needs to get all of these things under control. She did indicate to me that she is hopeful that she'll be able to get into a substance abuse treatment facility. So to the extent that the court thinks that additional jail time is necessary, I would ask the court to allow her to immediately be released into a substance abuse treatment program if she's eligible. She did indicate to me that once this is all behind her, she's hopeful that she'll find meaningful employment and be able to stabilize herself.
Thank you. Ms. Wheeler, was there anything you wanted to say today?
I'm sorry. I really am sorry. I'm struggling, not gonna lie. I haven't had the right resources. It's made it really hard for me. I want my sobriety more than anything in my life, more than anything. And I can't believe that my fucking life has came to this. I'm just really sorry. I really am.
Okay. All right, Ms. Wheeler, I'm familiar with your file. Of course, I presided over your underlying case, so I'm familiar with the circumstances that led to the probation. Based on Ms. Wagner's information she's provided today, the court's familiar with what has happened since you were on probation. I think one of the goals of your probation in this case was to get you help and get you some treatment. It appears that you did. You were referred to CHS for treatment, that you did enter a detox facility. It was recommended that you go into residential treatment to help you at that point, and you declined to do that. And, of course, then without that help and without accepting that help, you relapsed into using again. So from the court's perspective, there were some efforts made to get you the help that you need that you did not follow through with. So I think there should be some additional jail time as a penalty. As Ms. Wagner indicated, the guidelines are 0 to 6 months. The court finds that a 90-day sentence in the middle of the guidelines reflects the mitigating factors, but also addresses punishment in this case for your failure to follow through on probation. So the court is going to sentence you to 90 days in the Kalkaska County Jail with credit for the time served, which is, I think, 34 days, you said, Ms. Wagner?
Yes, I believe that's correct. Did I put it in that email? I'm just going back to try to find it. I thought I had notes that said.
I don't see that, but this says 24 days.
And that should be correct then, 24. I apologize.
Okay. However, Ms. Wagner or Ms. Wheeler, I agree that you need help and that you need treatment. And to the extent that you're willing to go to residential treatment and you can get a bed, I would allow you to be released prior to the end of that 90-day sentence to go to residential treatment.
I don't. Can somebody help me figure out how to do it from here? I don't even know what to do. Like,
you're going to need to communicate with the jail staff. They might be able to help you with that. I'm not That's not something that I'm involved in. I can't get that set up for you. All I can
Okay.
do is give you the opportunity, and then it's up to you to find out how to do that.
Okay,
Again, I mean, you had that opportunity on probation, so it didn't even have to get to this point. But we're at this point, and if you can work that out, I would allow you to be released. And there are ways that you can work that out through the jail, if you really want to.
Okay.
The court is going to discharge you from your probation. I don't, at this point, given the efforts and what's gone on, I don't find that it's in the interest of the community to continue you on probation. And so that means that the 7411 status would also be revoked. The court will preserve any outstanding fines and costs that remain. You do have the ability to seek an appeal of this sentence. We will provide you with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. And that will be provided to you at the jail as well.
Okay.
Ms. Wagner, is there anything else that we need to address for the record today?
Yes, Your Honor, it's actually 34 days credit. I just went back and looked. She had 31 days previously served on her original sentence and then 3 days from now, so 34 days.
Okay, all right, thank you for clarifying that. Mr. Seeger, anything else we need to address from your side?
No, Your Honor.
Okay, thank you. That's all for today, and good luck to you going forward, Ms. Wheeler.
All right, he abruptly cuts his feed. Let's go back to Colorado. This is still in Adams County, but different courtroom. This is Division 7. Pretty sure we're going to catch this in the middle of a sentencing.
Department of Corrections, I am going to sentence you in the aggravated range, given the fact that the defendant was on. Let me pull up the roll of them. On felony parole on Fremont case number 16 CR 232. Court's going to sentence you to 40 months in the Department of Corrections, specifically on count number 4. How many days credit does she have?
25 days, Judge.
Court's going to impose 25 days jail, give you 25 days credit on the misdemeanor. I will also give you 25 days credit as to the felony. I'll be followed by a mandatory period of 2 years of parole. Court will waive any waivable fees and costs. There is no restitution in this case.
There is not, Your Honor.
It's unfortunate that you're going to be going back to DOC, Ms. Raven. But I truly hope that you do some more soul searching. Okay?
Yes,
And that you come back out and never go back in. Good luck, Ms. Raven.
Thank you. Okay. Thank you.
Okay, we caught that at the end, unfortunately. When I go to Colorado, the way they do their feed, I'm not able to go back or anything, so we just kind of catch stuff where we catch stuff. But while we wait to see what they might queue up next in that state, let's go back to the northern lower peninsula of Michigan, but this time we'll go back to Judge Elmore.
Take it back. Actually, can I get this Weidman? Is it Weidman or Weidman?
Weidman.
All right, thank you. Sorry if I mispronounce it.
Okay.
This is Weidman's file. I gave it to you. Thank you. All right, so we're taking up the file of people of the state of Michigan versus Christy Lynn Weidman. This is file number 25-3628FH. Appearances, please.
Thank you very much, Your Honor. Attorney Robert Wrench, Assistant Prosecutor in Suffolk County.
Thank you, Honor Taylor and Anna Trevento on behalf of Ms. Weidman, who's present seated to my left.
All right, folks. Well, let's find out what's going on. I know we met and spoke about it, but why don't you guys tell me if anything's changed?
Thank you, Your Honor. So we received a new plea offer this morning. The people represent that they had their staff send it over to our office yesterday, but checking my file this morning, it was not in there. It's possible that it wouldn't have gotten processed until after I had left to come here this morning. I was in the jail room speaking with Ms. Weidman regarding this new offer when the court had needed me to come in for the prior matter.
Oh, okay. No problem. Do you need more time to speak with her?
I would ask if we could have a bit more time to talk and go over things. I will say I did meet with her earlier this week.
That's okay.
And this is where we are. Thank you.
All right. So, Ms. Weidman, you want to, now let me just keep plowing through the docket. Let's go ahead and Ms. Weidman, you can go on back with the corrections officer, and I will leave Ms. Ferravento, who has nothing else on the docket this morning that I see other than you. So she'll have plenty of time to speak with you. Okay?
Yes, sir.
All right, ma'am. Thank you very much.
Your Honor, quick question just to verify.
All right, let's go back to Colorado. Same courtroom. Looks like they've pulled up somebody else. We'll be able to catch this closer to the beginning this time.
22nd of July, so a little over 20 days here. He is, I'm sure the court can tell, in 70 years old and dealing with some significant health issues here. He went through with me all of the health issues. Suffice to say, it is fairly significant. He suffers from congenital heart failure. He has atrial fibrillation active at all times. He's supposed to be on a lithium-based medication that he's not currently getting in the jail. Sounds like the jail is working with him on some of his meds, and he's been really appreciative of that. But it's a work in progress to get the right dosage and times and things, which he had when he was out of custody. He lives at his mom's house. He's a partial caregiver for her. He's only physically able to do some things, minor things around the house, but it's important things for him and his mom. So he does have a place to stay. He's obviously on oxygen. His ability to walk and to breathe really are diminished. Can't do really any strenuous activity. I think this somewhat goes without saying, but jail is really no place for Mr. Brunmeyer, given the significant things he's going through. He wants to work on his sobriety. The day before the allegation in this case, he had an intake with a social worker to get into an outpatient substance use program. He understands that any bond would have supervised release with it. Judge, I know on a fourth DUI, a PR bond is not a common thing. If there was a case to give a PR bond for a fourth DUI, it's probably this case. His priors are, the most recent prior, let me put it that way, is 19 years old. And that's the last substantive case he's had. So this is not someone who's out there, racking up DUI after DUI. He hasn't had one in almost 20 years and is then accused in this case. I also would note for the court, I have no doubt that he will come back to court. The only failure to appear I see listed in his criminal history based on his CPAT is from 1980, and he has not had a failure to appear on any case since then. Obviously, he hasn't had a case in a very long time. The only case since 2014 listed on his CPAT was dismissed, he beat that case essentially. I don't know whether it was dismissed or not guilty, but it doesn't exist anymore. He was not guilty in that matter. And then he has a minor traffic case in Jeffco, I think, of careless driving. So ultimately, this is a case that I do think warrants a PR bond or a substantial deviation in bond. He really couldn't post anything over 1,000 cash or surety. I honestly think a PR bond is warranted here. His CPAT is listed as a total category of 4 and a score of 55. I think that is inflated. I don't see any evidence of revoked bond or supervision unless it's from that 1980 case. They list him as his age of first arrest, and I agree that's probably an accurate age of first arrest, though it was 50 years ago. They list him as all the references to the residence, things like that. He lives with his mother, so I don't think it's a reason he wouldn't come back to court. They list a past jail or work release sentence, but again, it's 15 years ago. So the purpose of the CPAT is not served by the numbers that they've been put here. They're frankly arbitrary. 13 points comes from a careless driving case in Jeffco. So I'm asking the court to consider a personal recognizance bond in this matter or reduce bonds as low as the court's willing to go.
Mr. Ray.
I have no objection to the court reducing the bond based on that record, Your Honor. I do know that the defendant's criminal history is much older. In terms of helping out his mother, I know that he was drunk outside of his mom's house when the police contacted him. So I do know that he lives with his mother. However, it was a cleaning lady or an assistant for his mother who ultimately called the police on him. So I do know that his mom has other help outside of him. As to the amount that the people are asking for, I would defer to the court. But I do think given the medical issues here and the older criminal history, I wouldn't be offended by a reduction of bond in this case.
I don't know by saying that I take these cases very seriously. The community safety concerns that the court has as it relates to these types of cases is significant. The court has reviewed the allegations in the affidavit. The allegations are concerning to the court. I appreciate the record made by defense counsel that the, I guess, most recent DUI other than this one was approximately 2 decades ago. Nonetheless, although these are allegations at this time, we are still here for what is charged as a fourth. As I stated, I have significant community safety concerns. I understand the prosecution has no objection to a reduction in bond. Quite frankly, I wasn't going to reduce bond at all. But since the prosecution doesn't have any objection to reducing bond at this time, and I want to be clear, I am sympathetic to the health conditions that Mr. Brunmeyer has. I understand that he needs to take care of his mom. He needs to take care of himself as well. But given the community safety concerns that the court has, I disagree with the defense that this is the type of case for a PR bond, but I will modify bond to $2,500 cash assurity.
Would the court consider 1,500? I think that's a stretch for him, but I think he might be able to do 1,500. Obviously with SRP and monitored sobriety and no driving as conditions of bond.
But I think she'll be responsive.
Mr. Brunmeyer, you understand the importance of maintaining your sobriety moving forward, sir?
Was working on getting back to sobriety the day before I got arrested.
Just answer my question, Mr. Brunmeyer.
I'm planning on being sober for the rest of my life. My goal when I got arrested was to.
Mr. Brunmeyer, I know you want to explain, and I'm not trying to be disrespectful. I just want you to be direct, and I'm being direct. Do you understand the importance of maintaining your sobriety moving forward?
Yes, I do.
You understand the importance of maintaining your sobriety throughout the pendency of this case? Or a modified bond of $1,500 cash assurity, SRP monitored sobriety. You are to report to SRP within 24 hours if you post bond. You understand that?
Yes, sir.
So he also gets services through the VA. It sounds like he'll have to call SRP, I think, but if he can coordinate the service with, okay. So you still have to check in with supervisor release, but you can also, you can probably get the VA and supervisor release to communicate and help. But you do have to get checked in with supervisor
Yeah, no, I'm moving to start.
Or buying this matter up to district court, correct?
Yes, could we set it on a Monday or Wednesday? Probably 4 to 6 weeks. He'll have to fill out a new public defender application and stuff like that.
Can we set it on a Wednesday, please?
October 8th at 8:30 a.m. in Division L.
I'm sorry, one more time.
October 8th, 8:30, Division L.
That works.
That should work for Ms. Gaffigan as well.
Thank you.
Okay, that's your next court date. It's 1500. Okay.
Thank you.
Okay, everybody, as we move out of courtroom ASMR, let's move into what we do here on Fridays, my friends. There's about 40 minutes left. Let's indulge in our guilty pleasure, shall we? It's the worst courtroom in America with the worst production values and horrible audio, which should sound great on the podcast end, but we know it. We love it. Ladies and gentlemen, da 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 dungeon court.
So the maximum penalty for this is 6 months in jail and a $1,000 fine. Do you understand the charge?
Yes, I do.
Do you understand your rights?
I do.
How do you plead?
Well, I was wanting to know if I could have it like pushed out like a month or so, because he told me if I could get it took care of. I had no clue what it was over. My license was hemmed up in West Virginia. I got about $1,000 to pay there, and by like the 1st of October I could have it all cleaned up and like okay. But
Okay, I'm going to enter a not guilty plea for you. You're entitled to have a court-appointed lawyer because this is a jailable case. Do you want to be considered for a court-appointed lawyer?
Sure.
Are you working?
Yeah, I work out of town, so like I work like I leave out on Sundays and I come back on Thursdays.
Well, okay. What I have to figure out is your gross annual income. Are you paid by the hour? How do you get paid?
Yeah, and I pay child support, all that. I bring home like after child support.
What are you paid per hour?
$22.50.
Okay. 40 hours a week?
More.
Do you know what your gross income is?
Yeah, about.
What?
About like $2,200 after child support monthly.
What do you show on your income tax return annual? That's what I have to determine your.
Oh, I don't know. I just started working out of town 1st of the year. I haven't got that yet.
Okay. I get, without overtime, you're making $46,000 a year, $47,000 a year. Okay. How many kids do you have?
Too many. No, I got 3, but I only pay child support on one of them.
So are you supporting the other 2?
Yeah, I got full custody of the other 2.
Okay, because of the number of kids, I'm gonna find you're eligible. Otherwise, you wouldn't be if you don't. Because you got 3 kids, I'm gonna appoint lawyers for you.
Appreciate that.
Mr. Stratton, we'll get him in here. Need Mr. Stratton in the courtroom, please. Mr. Stratton, this is Dustin Himes. He has a jailable driving under suspension charge, so I'm going to appoint you to represent him. All right. He says he thinks he can get things cured in about a month, so I think we should go at least that far out for the next hearing. I'm moving in October sometime.
Any day except October 13th.
Okay,
I'm out of town the 20th through the 24th. I won't be in town.
I'm sorry, what days?
20th through the 24th. So
Of October?
yeah, and if it's a Monday or Friday, like I could let my job know right now, hey, I ain't gonna be out till Tuesday, and then
Yeah,
work
we can set it
Tuesday.
before then, so October the 10th.
Okay.
You'll be in town then.
That'll work.
October 10th is your next hearing. It'll be a pretrial at 10 o'clock, and he lives out of town, so you may.
I work out of town. I live local. I work out of town.
Oh, well, it had a St. Albans address on here. That's not correct?
No, not now.
What's your current address?
383 Skyview Drive, Huntington, West Virginia, 25177.
he posted bond or not?
I never went to jail.
Okay, all right, then you don't have to sign.
October 10th, he can sign a $500 signature bond. I'm not gonna make you go get fingerprinted for a driving.
Okay.
That's a big one.
All right, thank you, Honor.
You're welcome.
State of Ohio versus Mike Ferris.
Thank you, Ron.
You're welcome.
Case number CRB 25247.
As he pulls up the next contestant, a reminder for old channel members, but also something for new channel members. We made a brochure for this court, and it's hilarious. So if you would like a copy emailed to you, you simply need to reach out on the member email. If you don't know what that email address is, just go watch any of the pre-shows. You'll see it displayed there, and I'll email you a copy. You'll love it.
Okay, what you owe is community service.
Yes, sir.
You agree with that?
Absolutely.
Do you have an explanation for missing before?
No, I was working and I just totally forgot about it.
Well, you got a rude reminder then, didn't you?
A real bad one.
You got
That's something.
arrested on the warrant.
Yes, Your Honor. That was something I definitely don't ever want to experience.
Yeah. It's a good idea to stay out of jail when possible.
Yes, sir.
Okay, so what I'm gonna do, now that you've got a bond up, I'll go about a month out, give you another review hearing. Well, actually be a sentencing now that you got a bond up. Well, I'll give you another hearing to look at your file. If you get it done, you don't have to come back.
What do I need to get done?
5 days of community service.
I can definitely have that done. Or is community service, can I do that every day, or is it only a certain time, or
Any day but Sunday here at the court at 7:30,
7:30 in the morning be here?
including Saturdays.
I'll start tomorrow in the morning.
Okay, that'll be great. Let me give you a date to come back. Hopefully you won't have to come back because you have it all done.
Yes, sir.
Okay, I'm gonna go into October. Let's make it October the 10th, and that'll be a sentencing hearing at 10 o'clock. You know what you need to do now?
Yes, sir.
Okay.
Now we'll get it done.
All right, you're finished.
Thank you, Your Honor.
You are.
State of Ohio versus Jessica Leanne Thomas. Case number CRB 25499.
And ma'am, you're Jessica Leanne Thomas.
Yes.
You got a complaint filed by the Ohio Department of Public Safety Investigative Unit alleging that on July 30th in Perry Township, you unlawfully did sell, distribute cigarettes or other tobacco products to a person under the age of 21. So that's a 4th degree misdemeanor, carries a maximum penalty of 30 days in jail, $250 fine. Do you understand the charge?
Yes.
Do you understand the rights you have?
Yes.
How do you plead to this charge?
Can I say something?
No, tell
No?
me what your
Okay.
plea is, then if you plead guilty, then you can say something. If you don't plead guilty,
Okay.
then you need to remain quiet, go talk to a lawyer.
Okay, I'll plead guilty.
Okay, guilty means you're admitting the charge is true. It waives your rights to have a trial, to have a lawyer. Do you understand that?
Yes, sir.
Okay. Before you say something, let me read what the citing officer says, and then you can respond to that. You may have something you want to say about that too.
Okay.
So because I've got a report in the file from them, so. Statement of facts. And they don't tell me their name, I don't see anywhere, but it's attached to a report that's in the file called Investigative Arrest Report. On July 30th, 2025, Ohio Investigative Unit agents Elliott, Rouse, and Love were conducting tobacco compliance checks during a project number, they give some number, at Leo's Carryout located at 1605 County Road 1, South Point. Agents utilized underage purchaser, age 17, date of birth January 2nd, 2008. The underage purchaser was checked prior to compliance check, equipped with an electronic recording device, provided investigative funds for tobacco purchase. Agent Elliott was assigned to the underage purchaser, and Rouse and Love were backup. At 6:20 p.m., Agent Elliott entered the premises, followed shortly after by the purchaser with a recording device being monitored. The purchaser approached the counter and asked on-duty clerk, identified as Jessica Thomas, for a pack of Newport cigarettes. Thomas retrieved the cigarettes, placed them on the counter. Thomas requested identification, which they provide their state-issued identification. Agent Elliott observed Thomas first visually inspect the identification and return it. Thomas requested $12.25 from the purchaser, which was paid using the issued funds. Thomas returned change to the purchasers, completing the transaction. Purchaser took possession, exited the store. Agent Elliott informed Rouse and Love of the violation. Love and Rouse entered the premises, identified themselves to Thomas, informed her of the violation. Rouse prepared to explain the issue. Thomas assignments to appear in Lawrence County Municipal Court for a violation of 292702B1, selling and distributing cigarettes or tobacco products to a child. Agents exited the permit premises a short time later without incident. All evidence was marked, secured. Evidence photos were taken and digital recordings. Okay, anything you want to say in response to that?
Well, I did check the ID. I read the ID wrong. I thought it said 2004. And I have a video from work from the security where like I turned around and looked at like above our time clock is like the under 20 or like over 21 sign. And we don't have a system at work where like we scan the ID or anything like that. We just look at it and give it back. And I thought I seen 2004 on the ID, so I went ahead and went through with the transaction.
Okay. You came in the middle of this, Mr. Hill. Do you have any input on this?
I haven't seen that particular ticket, but we had some in Ironton Municipal yesterday. And,
okay. So she's saying it was a mistake. So I have to look at the statute. I don't know if there's required to be intent here or not, or if it's some statutes like the speeding statute. It doesn't, because I had people come in and say, well, my speedometer was wrong or whatever. It doesn't matter on this because it's a safety statute. It's for, it's to keep people safe. It doesn't matter if you know or don't know that you're speeding. You're still guilty, even if you don't intend to speed. I'm not sure about this one, if there has to be intent. So.
What's the statute?
It's, I've got the number here on the citation. 292702B1.
Your Honor, it's put in the computer as 2935.081.
Well.
Two statutes in there.
I'm looking at the citation, it says 292702B1. So it was entered incorrectly, it looks like. Or either it was entered incorrectly or they cited the wrong statute. What's the statute? I haven't looked at the statute, Mr.
The statute is titled illegal distribution of or permitting children to use cigarettes or other tobacco alternative nicotine products. So I don't know if there's a separate one for, in the case of a store clerk or.
2935.081 comes up in the computer as selling cigarettes to a minor.
Well, the citation is not that. It's 20. It should be amended, and that's the wrong statute in the computer.
I think it's just a typo area. Could you repeat that and I'll change it?
It's well.
Distributor, wholesaler,
This is. I think where they picked this up. This is where this agent signed the complaint. It says, peace officer authorized to administer oaths pursuant to ORC 2935-081. But the actual statute that's allegedly violated was 2927-02B1. Yeah. So what I'm going to do, Ms. Thomas, I'm going to take your plea under advisement. I'll look at the statute. This is like technical legal stuff, so. But that's important. We have a system of justice. We're following the rules.
Yes, sir.
So there are certain statutes like where it's really important what the intent is. Like if you're driving down the street playing with your radio and go left to center and kill somebody, that's not murder. It's going to be something less than murder because you didn't intend to do it. If you take a gun out and purposely kill somebody with the gun, that's murder because you intended to do that. In our system, which came from England, intent was really important. So I don't know if this, under this statute, they have to show you intended to do this, or if it just, whether you accidentally or negligently did it is enough. So I'm going to take it under advisement, research and see what's required, and then I'll issue a written decision as to what should happen, and then I'll probably set another. Well, let's do this. I'm going to go ahead and give you another day when you'll have to come back, because you'll either have a fine and court costs or the case will be dismissed. But if it's going to be dismissed totally, you won't have to come back. But the state may want to, they may want to say, well, we think we've got evidence of intent. So, so I'll take it under advisement. I'll issue a written decision, and it may set another date, but I'm going to go ahead and set one now. I'll set it as a sentencing hearing. Let's do it the 15th. Does it matter what day of the week? It's going to be Mondays or Fridays?
Monday would be better.
Okay, that's what I was going to do. September 15th is a Monday. Set it as a sentencing.
And Your Honor, going forward, if we get more of these, does the prosecutor want us to do them on the complaint that's presented by the investigative unit, or do you want to do them?
Well, the one that's presented by the investigative unit is fine. I guess what I want to do is get a copy of it so I'll be prepared to talk about it when it's called up.
Yeah, they came in and filed on their own. I know some agencies, you want them to present it to the prosecutor's office first before, and then you file the complaint, but they brought it in to the clerk's office and wanted to file it.
Yeah, and even if they do file it, it's better if I know about it before it's called up for an arraignment.
All right, ma'am, I'm going to let you sign a $500 signature bond. What that means, you just sign a piece of paper that says, I promise to come to court when I'm ordered to. If I don't show up, I'll owe $500 for not showing up. So just come to court. You don't have to worry about paying any money for the bond. You have any questions, ma'am?
I don't think so. Can you change my address because I moved?
Yes.
Okay.
What is your correct address?
1173 County Road 1, Lot 24, South Point, Ohio.
Okay, you've got it down. Okay, you'll get something from the court, but if you don't, otherwise, you need to be here as of now on the 15th.
Okay.
You should get something in writing from the court before then.
Okay.
Okay, that's all.
Thank you.
You're welcome.
State of Ohio versus Craig Adkins, case number TRC 25, 2014, A3.
Sir, are you Craig Atkins?
Yes, sir.
Mr. Atkins, the state's alleging that on August the 10th at 7:50 p.m. in Rome Township, you were operating a vehicle while you were under the influence of alcohol. The state's alleging that they gave you a breath test and you tested 10. I'm going to round it off a little bit. 10 on the breath test. The per se level under Ohio law is 8. And what that means is if the state, and it's a big if, they have to show compliance with the rules for giving the test, there can be a presumption that you are impaired if you test 8 or higher. And they say you tested 10. It's also alleging that this would be your first conviction if you got convicted. On a first offense, the maximum you face is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most the court can do legally. There is a minimum, so the least I can do, if you're found guilty, is give you 3 days in a treatment program, $375 fine, and a 6-month license suspension. Do you understand that's called operating a vehicle intoxicated? Do you understand that charge?
Yes.
Then you've got a speeding charge. So as you're driving 67 in a 55 zone, that's not jailable. The maximum penalty is $150 fine for that. So those are the 2 charges. Do you understand them?
Yes, Your Honor.
Do you understand your rights?
Yes.
How do you plead?
No contest.
If you enter a no contest plea, what you're telling me is, I'm not admitting I'm guilty, but I'm not denying it either, and I'm agreeing that you can find me guilty if you look at the evidence the state says it has, and you believe that's legally sufficient for a conviction. And you're doing that without a trial, without talking to a lawyer.
Yes.
Is that what you want to do?
Yes.
Okay. I'll accept your no contest plea. Do you have a report on this, Mr. Jordan?
I do, Your Honor, and this is from Trooper Elliott of the Ohio Highway Patrol. August 10th, 2025, I was on patrol in my marked Ohio State Highway Patrol cruiser on State Route 7 traveling southbound. I observed a motorcycle at a higher rate of speed and checked the vehicle's speed at 67 in a 55-mile-an-hour zone. I then turned around and activated my overhead emergency lights to conduct a traffic stop on the motorcycle. The driver was later identified as Craig Atkins. Once I made contact with Atkins, I observed the strong odor of an alcoholic beverage coming off of Atkins. Atkins asked me if he could smoke a cigarette, and it appeared as if he was trying to create distance between me and him. I asked Atkins how much he had to drink today, and he told me he had 1 alcoholic beverage. When Atkins took his sunglasses off, I observed watery and bloodshot eyes. I then asked Atkins if he would go through some standardized field sobriety tests to make sure he was okay to drive, and he agreed to do them.
I hereby sentence you to a
Once
term of
Atkins agreed to
5
do the
years.
standardized field sobriety test, I asked some pre-medical check questions. I asked Atkins if he had any head, back, neck, or knee issues, and he told me he did not. I then asked if he was on any medications or wore contacts or glasses, and he said no to that as well. I had Atkins stand with his, this is the horizontal gaze nystagmus test. I had Atkins stand with his feet parallel together and interlace his fingers and place them under his chin. I then did my pre-medical check. Once I did that check, I went into lack of smooth pursuit where 2 clues were observed. I then conducted distinct and sustained nystagmus at maximum deviation, and 2 clues were observed. The final horizontal gaze nystagmus test was onset nystagmus prior to 45 degrees, and 2 clues were observed as well. I then proceeded to do vertical gaze nystagmus. While administering that test, vertical gaze nystagmus was not present. Walk and turn, I had Atkins get into the instruction. While I was demonstrating this test, the first clue I observed was moves feet to keep balance while listening to instructions. Once this test was demonstrated, I had Atkins begin the test. Once Atkins began the test, the clues I observed was loss of balance while turning and turns incorrectly, raises arms above 6 inches. 1-leg stand. Once this test was demonstrated, I had Atkins begin the test. Once this test was demonstrated, the clues observed was foot down and sways while balancing. I then placed Atkins under arrest for a suspected OVI and advised him of his Miranda rights. I then did a search of Atkins' person and placed him in the rear of my patrol car. While I was transporting Atkins to the Ironton Highway Patrol, I asked Atkins how often he drinks, and he told me he drinks every day and every night before bed. A BMV 2255 form was read and witnessed. Atkins agreed to provide a breath sample. Breath sample provided was 0.03 grams per 210 liters.
All right, Mr. Atkins, do you have any statement or explanation you wish to make? You're not required to.
No, Your Honor.
I've got a Parkerville address for you, is that correct?
Yes, Your Honor.
Okay. All right, on the first offense ODI, it is over the first day level, and I'll make a fine based on the officer's statements.
Yes.
And I'll make the finding of guilty on your no contest plea. There's a $450 fine. It's near the minimum, but not exactly the minimum. Or you pay the court costs, $125. You'll get a copy.
Oh.
She's typing it up.
Oh,
I'm saying it.
Okay.
So you don't have to make notes. You'll get a copy of the judgment entry as well. Says what your sentence is.
Yes.
You'll get a copy of it before you leave today. You're going to get a license suspension for 6 months, and that started the date of the incident. You did have insurance, so I can give, there's 2 types of permits I can give you. I can give you a limited driving privileges, which means you can drive for certain, like employment, certain things I would allow you to drive minimally. Or I can give you unlimited driving privileges, but to do that, since it's an alcohol involved, you have to place, what people commonly call the blow and go device on a vehicle, and that's the only one you can operate. So, do you want the limited driving privileges, or do you want to place? You have to pay.
The limited is fine.
Okay. So I'll give you limited driving privileges for work, community service. You'll have community service to do.
Yes.
To go to the DIP school, driver intervention program school. That'll be a part of your sentence. And to come to court hearings. Anything else that is like an emergent need to drive.
I take care of 2 older people's grass.
Well, that'll be part of working.
Okay.
You get paid for doing that? Or?
Yes.
Okay, yeah. Here's the thing on that. Or is that here locally in this area?
Yes.
Okay. You won't have too much trouble locally. I have had some people, particularly in Kentucky, that, because I'm going to give you a piece of paper for me, it says, yeah, this guy's license suspension, but he's got a right to drive for these reasons.
Right.
The only place we've ever had trouble was in Kentucky. They said, well, I don't care what that judge says, you're suspended.
I understand.
Here's the thing, the best thing to do, don't get stopped.
Yes.
Use your
Do
turn
laws.
signal. Okay, don't give the officers reason to stop you. It's not that hard. Just obey all the traffic laws, and you won't get pulled over usually.
Yes.
When you get pulled over, you got a lot of explaining to do.
I understand.
That's not to get in that situation. Okay, so you got 5 days of community service to do.
Okay.
We've got a community service program here. You can work any day but Sunday here at the court at 7:30, even Saturdays.
I'll start it next week.
Okay. And you got that, and you got to go to the driver intervention program. I either got to make you go to jail or go to that. You would rather go to the 3-day driver intervention than go to jail.
Yeah, we've done checked on it. Yes.
Okay. Okay. Get that done. You don't have to go, there is one here in Orange County. You don't have to go to that one. You can go to any one that's approved by the state of law.
Yes.
And there's some cheaper ones out there than the one here.
Okay.
On the speed offense, I'll impose a $40 fine.
All right. Thank you.
So, you have to talk, your probation officer his office is to the left as you leave the courtroom on the west side of the building. There's the counter on the right side is the clerk's office, on the left is probation. Go check in with probation, he'll give you a copy of the judgment entry that has all that stuff in it. If you lose it, or don't remember what you're supposed to do, it's on, we have a website. Your name is in there with your record, or the clerks, you can call in.
Yes.
Well, I lost my judgment entry. I didn't know what I was supposed to do, so I just didn't do anything. That's not a good reason, because you can get the information. Just call the court or check on it online. I'll set your review hearing for February the 20th, so that's way out there, 6 months. You have plenty of time to get it done. If you do get it done, you don't have to show up.
Okay.
If you don't have it done, you got to show up and explain why you can't get it done and ask for more time.
Yes.
Any questions?
No, Your Honor.
Okay, go, Mr. Major is the name of the guy that's your probation officer, go check in with him. You're free to leave after work.
Okay, so Michael Groff, great friend of the show, and I believe a link was just dropped in the chat for his channel, sent me a custom audio that I was trying to get set up, and I think it played while I was trying to get it set up, because doing this stuff on the fly is sometimes tedious and difficult. But let's play it proper now. This is a fusion of the Colorado judge with Dungeon Court in Michael's interpretation. So let's give it a listen.
I hereby sentence you to a term of 5 years in the Department of Corrections and a fine of $5,000, along with restitution, or your immortal soul.
Thank you, Michael. I appreciate you sending that to us. Let's get back to the real villain of this court.
Okay, well, now you've got a bond up, so I'm going to put you on the sentencing docket for that, but it's the same thing. I'm just going to check on you periodically to make sure you're getting this done. If you don't show up now, what's going to happen is when I issue a warrant with the bond up, the bail bondsman doesn't want to have to pay the bond, so he's going to come snatch you up.
Yeah.
It's not going to lay there. Like the sheriff is not going to run. I hate to tell people this, but it's the truth. So I issue a warrant for failure to appear. The sheriff's not going to immediately run and get you, but the bail bondsman is, because he didn't want to pay any money. The sheriff doesn't have to pay us any money if you don't show up.
Yeah.
The bail bondsman does, and he doesn't want to pay money.
The last time in this court, he called me and told me that I needed to come in, and I didn't hear nothing from him. I just thought,
In this case, no news was not good news. No news was bad.
That's how it usually goes. No news, bad news. But got pulled over Sunday and ended up in Sauter County Jail. And
oh, okay, you're the one that was inside county.
yeah, bonded out Tuesday because they were trying to get you guys to come pick me up, but Lawrence County wouldn't come.
Sheriff didn't want to go down there and get you.
Yeah.
I heard about that.
Yeah. I
So
said
they
that.
released you from the jail in Portsmouth? Is that how you?
Yeah, after I bonded out through Sowards.
Okay.
Finally got out almost 4 o'clock that evening, Tuesday evening.
All right, so I'm going to set it for September the 19th. As your next hearing will be a sentencing. Get it done before then, you don't have to come back. I'm showing you $100 and 3 days community service.
We'll get taken care of.
Thank you. Okay, you know what you need to do.
Yep, pay the $100 fine now and do 3 days community service.
Get that done before September 19th, and you don't have to come back.
Gotcha.
Okay.
Can I come down here on Saturdays and do that?
Yes.
All right.
Any day but Sunday, we've got community service here.
All right.
Or a holiday. If it's a holiday, we won't have community service.
All right, I appreciate you. And sorry for all the inconvenience.
That's why I'm here. Inconvenience.
Thank you.
You're welcome.
State of Ohio versus Earl Carter, case number TRC 25-1974, A and B.
Sir, are you Earl Ray Carter?
Yes, sir.
Mr. Carter, it's alleged that on August 12th at 12:11 a.m. in Perry Township, you were driving a vehicle while you were under the influence of either alcohol, drugs, or some combination of those two things. And the state's alleging you did submit to a urine sample, or give them a urine sample. Those get sent off to a lab for testing, and it takes too long to get them back, but it's 9 or 10 weeks before we ever get the results back, so I don't have any results today. It's alleged to be your first offense. So on our first offense, the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. There is a minimum. I can't go below 3 days in a treatment program, $375 fine, 6-month license suspension if you're found guilty. Do you understand that charge and the possible penalties?
Yes, sir.
Then the other charge you have is failure to display plates. That's a minor misdemeanor, maximum penalty is $150 fine. Do you understand the two charges filed against you?
Yes, sir, but I'm driving the car and it's got plates on it, and it's had plates on it since.
You know what, sometimes they make mistakes, it may not be true, I'm just telling you what's alleged.
Okay, I want to plead not guilty, sir.
That's what's alleged. Okay,
Yes, sir.
I'll enter a not guilty plea for you.
Thank you, sir.
Do you wish to be considered for a court-appointed lawyer?
Yes, sir.
Are you working?
No, sir.
You don't have any income?
Yeah, I get Social Security.
That's your only income?
Yes, sir.
I'll appoint Roger Smith to represent you. He's here, so we'll get him in the courtroom. Mr. Smith, this is Will Carter. It's a first offense OBI with a urine screen, so it's going to be a while before we'll have those results back. So I'm looking at maybe 8 or 9 weeks out before we come back. The eighth week is the 10th, the 9th week is the 17th of October.
Far enough that this should be okay. Let's see. I can do, yeah, Friday, the 17th of October.
Yeah, is that good for you?
That is good for me, Judge, yes.
Okay, October 17 will be the next hearing. It will be a pretrial 10 o'clock. Mr. Carter can sign a $1,000 signature bond. Not guilty, please, and he needs to be fingerprinted, yes. He'll need to go also as a condition of bond to the jail and get fingerprinted. Mr. Cooper's going to bring you a form that you'll have to take with you to the jail for the fingerprint.
Just wait on me, I'm the one, I'll bring you to this. State of Ohio versus Martinez Fernando, case number TRC 25, 2018 A and B.
Sir, are you Martinez Fernando?
Yep.
Mr. Fernando, it's alleged on August the 9th at 1:40 p.m. in Fayette Township that you were driving a vehicle under the influence of alcohol and took a breath test for alcohol and tested 11 on the breath test. And it's alleged to be your first offense. 11 is over the per se level of 8. The Ohio law and most states, I think now, if you test 8 or higher and the state shows compliance with the rules for giving the test, there can be a presumption that you were impaired. Do you understand that?
Sir, I don't know speak English.
All right, hablo español.
Sí.
Is there anyone with you that can translate? Do you have anyone with you? Is there anyone with Mr. Fernando? All right, and would you identify yourself? Yeah. Can you speak English? Habla English? Habla English? Well, look, I can get a translator if you want, but it's gonna, I'll have to get it on the phone. It's gonna be a while. So maybe that's what we should do. So just have a seat. We'll recall him. We have to call the Ohio Supreme Court, get a translator on the phone. We can do it that way. Are you understanding what I'm saying? Okay. We'll do that. I'll recall it once we get a translator on the line. So don't leave the court. We'll recall the case.
Well, friends, it is that time, so I guess we're going to have to leave it on that cliffhanger for this week, and hopefully they get somebody to translate how his soul will be taken from him. I hope you all had fun this week. I know I did. Today was another great day, as they all are, really, but I had a lot of fun today. Thank you, Ashley, for gifting 20 memberships. Incredibly kind of you. Thank you, Michael, for the audio that you sent us there at the end. Super cool. Michael is very talented. If you're not already subscribed to his channel, a link has been dropped in the chat a little while ago. Go subscribe to his channel. There is no reason why he should have less subscribers than I do, because he does this way better than I do. So give him your support. We'll be live on this channel again tomorrow night, 8 p.m. Eastern, 5 p.m. Pacific, where we will have game night. I'm not 100% certain what we're going to play yet, but we'll figure that out. So join us. We don't do court. We just play some video games and kind of chill out and enjoy each other's company. So join us for that. And then we'll be back for court on Monday, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. So be sure to give that a look come Monday. And I did not shout them out today, but be sure to check out our sponsor, Aura, aura.com/TCF. There is a link down in the description. You get 2 weeks for free. As I've been saying for a couple of weeks now, your data is all over online. We know that. We watch enough court to see that there are bad actors out there. And Aura gives you 2 weeks for free through this channel for testing them out to see what they can do for you, and you will not be disappointed. So give them a look, support the people who support this channel, and help yourself. Aura.com/TCF. All that having been said, go have yourselves a great weekend. I hope to see you on Saturday night for game night, and if not, we'll see you Monday. Take care. God bless.